22/25, the Hon'Ble Court has asked to call for the trial court record. But the case is district. For bailment? No. Please give it. I will pardon my lord. Another matter in this case. Give it. Okay. I will pardon my 2018 matter. Petitioner is 90 years old, and in spite of Supreme Court's order, the order he has not got the benefits, my lord. What type of benefit? It's a calculation of scale of pay. 90 years. So, 90 years. Give it. At 21, the Judge Criminal Appeal paperwork has not been prepared. That is in the second hour, not second.
Weekly list item number 1.
Additional activities in the prosecution. And this is against the order of Lawrence Central Administrative Tribunal. Lawrence Central Administrative Tribunal dismissed my original application, which was filed challenging the order of disciplinary authority, dismissing from me from the service, invoking power conferred upon the authority under Article 311(2) read with 19(3) of the CCA rule. Here, I was put under the suspension under Annex 2, that invoking power under 10(2) of the CCA rule. That is Annex 2. Your Lordship may kindly turn the Annex 16 page 63. Yes. Your Lordship may kindly turn to paragraph 15. At page 73. This is the Lawrence Tribunal has given the findings basing upon the averments made in the counter ruling. On the other meritless. Then we come to the first paragraph. Applicant, while working as Assistant Director Aviation Research Center in SAT ARC, Charvatia, had been on casual leave from 16 to 18th December 2016, and as such he was to report for duty on 19/12/2016. On 16/12/2016, an FIR was lodged against him by Gutti police station in the district. Bhagwati police station in the district of 24 Pargana, North Kolkata, city by Sri Aninda Sundar Bhattacharya, ACP, BDNPC, Airport Zone 2, for applicants' involvement of offences under section 370, 370B, 2, 120B, 34 of IPC, read with section 345B, 5C, 7, 9 of the Immoral Traffic Prevention Act 1956, which form the subject matter of Bhagwati PS case number such and such. Consequently, the applicant was arrested and remanded to the jail custody till 23/12/2016, when he was enlarged on bail. According to applicant, he thereafter reported for duty on 2/1/2017 by submitting the required documents. However, by the order dated 3/2/2017, he was placed under deemed suspension from the date of his arrest, that is 16/12/2016, on the ground that the detention of judicial custody was beyond 48 hours. This suspension was extended from time to time. On 31/10/2017, the applicant was issued with a memorandum by the Annexure 6, whereby he was called upon to explain his conduct on FIR number such and such dated 16/12/2016. In response to this, the applicant submitted his reply on 14/11/2017 Annexer 7 series, stating that he is not guilty of the charges leveled against him. However, by memorandum dated 23/11/2017 Annexer 8, the applicant was asked to submit the following documents: English translation version of all documents enclosed with which are in Bengali language. Complete
What
documents.
happened in the disciplinary proceeding?
No, disciplinary proceeding has been withdrew because keeping in view the nature of allegation.
Disciplinary proceeding they have not initiated.
Exactly what I am saying
Yeah.
has been withdrawn. Again, he has not been
That
gone through the disciplinary action, keeping in view the gravity of the offense.
yes.
Vis-a-vis the position that the petitioner is having in the intelligence service.
ARC Charbati.
ARC Charbati.
I'm working. I was working as a assistant director ARC Charbati.
Exactly.
And on the date of my when I was on leave, I have attended one spa. Unfortunately, raid was conducted. All the boarders of that spa were arrested on the allegation that illegal trafficking has been going on there. And I was also remanded to jail custody, and subsequently I was bailed out by the honorable.
The day you went on leave on 16th.
Yes, sir.
Having reached Calcutta,
yes,
you had been to a spa.
Yes.
And according to your case.
Yes.
And while in the spa, there is a raid by the police, and you were caught.
Yes.
With some ladies, and that is how you have taken to the custody.
Yes, sir. And thereafter, I was put under the suspension, invoking 10(2). Your Lordship may kindly appreciate, my Lord. 10(2) of the CCA rule. 10(2) of the CCA rule says, if a person was arrested and remain in custody more than 24 hours, 48 hours, then that he will be deemed to have been suspended. But now that subsequent actions they have taken, invoking that Article 311(2) and 19C, that in that situation only that Rule 10(1) clause A has to be applied in the event any such allegation is there. They have only allegation that transfers from the FIR Annexer 1. Annexer 1 says I was caught or I was detected when I was in a spa, and whatever allegation they have made. But here that they have invoked Article 19, Rule 19(3), Rule 19(2)(3) C. That where
ultimately the punishment of
dismissal
was mainly on the ground that you are detained in judicial custody for more than 48 hours, relating in connection with an FIR which was lodged against you. So that order you challenged before the Central Administrative Tribunal. What ultimately the tribunal held?
Honorable Tribunal has
paragraph 16 is the relevant question. That is the finding of the learned 16 at page 75.
Okay, please come to that.
We have
Please.
We have considered the rival submissions in their admittedly, the applicant was a senior officer handling personal issues relating to ARC personnel based in Charvatia. His direct involvement in a criminal activity like illegal trafficking of women and their sexual exploitation as part of an organized criminal racket in undoubtedly and unbecoming on the part of the government servant. Of the preamble of Intelligence Organization, Restricted of Rights Act 1985, providing restriction of certain rights conferred by the Part 3 of the Constitution, the members of certain organization established by the central government for the purpose of intelligence or counterintelligence so as to ensure the proper discharge of their duties and the maintenance of discipline. It is an admitted fact that on 16/12/2016 an FIR was lodged against the applicant by the SCP BDNPC Airport Zone 2 for application such and such, read with such and such. And this being the subject matter of by PS case number such and such, applicant was arrested and remanded to the jail custody and subsequently released on bail on 23/12/2016. From the above, it is clear enough that applicant being a responsible officer of an organization which has formidable role concerning the security protection of the country. Perception of the country. The potentiality of the above act on the part of the applicant being prejudicial to the interest of the sovereignty and integrity of the country cannot be dispelled because the applicant is a responsible officer of intelligence organization and there is every likelihood of the security being vulnerable in the case the applicant is allowed to continue in the organization. In such an eventuality, there was every reason for the respondent to do away with the departmental inquiry under the relevant rules of the CCA rules 1965, and to this extent, they have not acted divorce the rules, and thus the point of issue is answered. Last but not in the least, we have gone through the report of the committee shown by the respondent during hearing of the way, and upon perusal of the same, we found reasons recorded for dispensing with the regular inquiry under CCA rules are wholesome.
So, what happened in that criminal case?
Criminal case is still going on, my lord.
Okay. So, what is your submission? How do you assail the order of the?
Lord, it is only on the basis of assumption and presumption.
No.
And till my lord, last of the order, my lord, their document and the order of the learned tribunal. Everywhere it is says that my involvement in that.
What is the finding of the learned disciplinary authority?
No finding, nothing, my lord.
It's a order of the.
Nothing, my lord. Only you are hereby terminated from service.
Where is that order of the?
That order where the authority has dispensed with the inquiry.
But that no, that order has been given to me, my lord.
But
and only your lordship kindly turn to
no inquiry was conducted.
No charge sheet was given to me.
So like
Annexure 12 is the order.
Annexure
12.
Page 30.
Page 38.
No charge sheet, no dispensing, and only order.
No, charge sheet comes only when there is a.
You have been inquiry is required, charge sheet is
inquiry was
dispensed with.
Yes.
Inquiry was dispensed with in view of the issue that the matter involves security of the nation.
Allegation is this, and that
is
it may lead. Their allegation, it may lead.
So
that is the settlement.
Here, lordship kindly see. May place that.
What is your ground of challenge?
Ground of challenge when throughout the allegation of that under section 370, 370B and so far as criminal acts are concerned, imposing the punishment invoking article 311 to read with 19.3 does not arise. Here nowhere it has been indicated that this leads. I have my involvement in respect of affecting the sovereignty and the integrity of the country.
How you say this? Have you challenged the criminal action? Have you challenged that criminal action?
That is pending. That is going on now.
For passing, basing on the any of the act that you perform.
No, I have not challenged.
You are facing it.
Submission.
You are facing it.
Yes, ma'am. Yes. Because it is only allegation.
The case has ended in submission of charge sheet or no?
Charge sheet submitted.
Under what offences charge sheet has been kept?
Charge sheet is
same offences. As in the affair.
Have you given that charge sheet copy?
Charge sheet copy, my lord.
Charge sheet copy, my lord.
Sorry. But the offences are reflected, my lord.
No. The offence might be reflected in the FIR. We want that what is the offence under which charge sheet has been submitted and also the stage of the trial. That is
You'll have to kindly give me some time so that I can collect.
All right, collect it. The petitioner CHITTARANJAN was serving as Assistant Director, Aviation Research Center, ARC, at Charbatia, from a Chodwar from a Katak. I challenge the order dated 15th February 2018. The annexure 12 of the Government of India and the order dated 17/1/2020 passed by the Land and Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/207/2018. The reading of the order, impugned order under annexure 16 indicates that Bagui Ati, PS case number 191, dated 16/12/2016, was instituted against the petitioner for commission of offences under section 370, oblique 370, capital G, bracket B, oblique 120-B, oblique 34 of IPC, and
That is-
sections 3, oblique 4, oblique 5B,
378
oblique 5, capital C,
378
oblique 7, oblique 9 of Immoral Traffic Prevention Act 1956. And in connection with the said case, the petitioner was taken into judicial custody on 16/12/2016 and he remained in custody till 23/12/2016. When we put a pertinent, made a query to the Land and Council for the petitioner about the status of such criminal case, the Land and Council for the petitioner submitted that it is still sub judice, that the Land and Council for the petitioner filed a copy of the charge sheet. So also produce the documents relating to the status of such case. Keberakyo on the bill, put up this matter in the week commencing from 12th of May 2025.
Additional appeal council
Item 2.
My lord, on behalf of Suryanarayan Vishwa, my lord, kindly allowed to be withdrawn to file special petition.
Where is your memo? What is your name, Land and Council?
S.K.Sahoo.
You have got no power in this case.
No, my
And who has signed that memo?
lord, sir.
Yes.
Suryanarayan Vishwa.
Also files a memo signed by Mr. Suryanarayan Biswa, the Land Council for the petitioner for withdrawal of the petition. खाली लिखा है withdrawal नहीं तो अब किसी लिखा नहीं.
My lord, to file better petition.
No, you have not written it.
My lord,
Sorry. लिखा है. You liberty to file a better writ petition. Memo is taken on record. Writ petition is disposed of as withdrawn, given liberty. Yes.
God bless.
Item 3.
Item 3, my lord. In pursuance of my lordship order. So I spare some more time because you are sending that letter, and the Tahsildar Jagatsinghpur has sent the letter to also the Raghunathpur regarding the status of the case, my lord. So they are not provided all the documents. So I pray,
From the order dated 26/3/25.
my lord. Lead an affidavit operating
No,
partner.
no, please come to the from the form. Beginning you did it. 26/3/2025 ର
My
order.
lord, my lord.
ପଢନ୍ତୁ।
In term of the order dated 22/2025, and Council for the State has produced written instruction received from Tahsildar Raghunathpur, which indicate that as per the order dated 26/4/2018 passed in WBS number 17072/11, one D reservation case number 3/19 was instituted in the office of the Tahsildar Raghunathpur, and it was sent to the district office Jagatsinghpur regarding approval of the deregister of proposal in favor of the petitioner. It further appears that letter has been issued to the learned acquisition officer, collector, Jagatsinghpur on dated 13/11/2019 for payment of compensation amount in favor of the beneficiary, late Bobby Malik, the father of the petitioner. However, no information has been received from the land action officer. Let an affidavit filed by the land action officer, collector Jagatsinghpur, regarding the status of the payment of the compensation in favor of the beneficiary, late Bobby Malik. The Council for the State shall also obtain instruction about the status of the deregister case number 3/2019. Letter dated 17th furnished by the learned Council for the State. Second record. This is matter on 15/4/2025. Copy of the act will be served on the learned Council for the petitioner in the meantime.
So affidavit besides the status.
Status as well as the amount has been.
So what happened? You not obtain any instructions.
That's why I'm saying I have given the letter, and the Tahsildar Jagatsinghpur also present, come to the office and discuss with us. But as they are the whole cases and the land has been acquired by the railway, so he has sent the letter to the Tahsildar Raghunathpur regarding the that status of the land. So I pray for some more time as the last time, so I can.
So tell us the date when this is order was a detailed order passed on 22/2025. Then another order was passed on 26/3/2025.
I understand.
So what time you require? Tell us so that let it come after summer vacation, but you gave spring or land council for the state 6 time or 4 each time also to obtain instruction and also to file affidavit in terms of the order dated 26/3/2025. Put up this matter to opening week টা ছাড়িয়ে তারপর উইকটা নিয়ে যাবে না summer vacation পরে. Yes.
Item 4.
May I pray for this matter one week after? You are making a prayer for disposal of the resumption case within a stipulated time. And the resumption case number is 3 of 1995-96. Now, why are you asking for time?
Where's the last chance, my lord? I am not ready.
No, why you are asking for?
No.
If it is still pending and it has not been disposed of, then we can certainly ask that about the status. Why are you asking time? You are the counsel for the petitioner.
My lord.
If this is the limited prayer in your writ petition, we are asking you that why are you seeking for adjournment?
Actually, my lord, I have not gone through the brief.
No, a type of case would have brief ପଢିବା ପାଇଁ କେତେ ସମୟ ଲାଗିବ?
Absolutely, 1 week after.
What is your good name?
Sudeep Solanki.
Sudeep Solanki. So by the way, you obtain about the status of that case because that is the limited prayer.
It has been issued with a notice and annexure 5, 3/1/2025 to be present. And what happened?
It has been granted for the purpose, and in the
No,
meantime,
it's all right, but you have been issued with a notice to appear before the authority on 3/1/25.
He just wanted that particular case to be disposed of.
And but
Because
his notice
at least this notice shows
विचार ପାଇଁ 31 ଦିନ ସମୟ ରଖା ହେଲା. You appear.
resumption case କୋଉଠି ଅଛି?
ଏଇଟା କେତେ କେସ୍ ଏଇଟା ମିସ୍ କେସ୍ number 45 of 2000. This is another case. This is 45 of 2024. Dakhal Kharaj. There is a mutation case as it seems. Arising out of not final case. Miss case.
Annexure 1 ଟା ହଉଛି ସେ ଯୋଉ case ର resumption case number କଣ ସବୁ ଦିଆହେଇଛି ତା ଡେଟ୍ ପଡୁଛି 26/5/2000 ରେ ବିଚାର ପାଇଁ ଧାର୍ଯ୍ୟ ରହିଛି.
But earlier this court had directed to dispose of that case. In view of the above, this court disposes the writ petition directing the collector to dispose of the resumption case number 3 of 65, 95, 96 in accordance with
Case 23/25 କୁ ମଧ୍ୟ ଗୋଟେ ଡେଟ୍ ହେଇଛି. Case 20 ରେ ମାନେ ଗୋଟେ ମିସକେସ୍ ଫାଇଲ୍ ଡେଟ୍
WI case number 2434 of 86.
and the exemption case would have
There was already a direction another annexure 4.
yes, Lord.
So
It has been granted in favor of the petition. In the meantime, they are not
the direction was
carried out that release. Thereafter,
the resumption proceeding perhaps was initiated, but as it appears that is still
we take instruction on that respect.
pending since 2013 ମସିହାରେ ତ we are in 2025 so ବର୍ତ୍ତମାନ ବି prayer କରୁଛନ୍ତି ଯେ ସେ resumption so take instruction about the status of this. This writ petition has been filed by the petitioner Kartik Chandra Behera. It's a prayer for a direction to the opposite party number 1, Collector cum District Magistrate Khordha, to dispose of resumption case number 3/1995-1996 within a stipulated period. It appears that earlier the petitioner approached this court in WKC number 21907 of 2010 with a similar prayer, and a division bench of this court had order dated 21/6/2013 has been pleased to direct the opposite party number 1 to dispose of the said resumption case in accordance with law as expeditiously as possible. Let the learned counsel for the state obtain instruction regarding the status of resumption case number 3/1995-96, which is stated to be pending before the opposite party number 1. Put of this matter, eta to 2 सप्ताह भितर हेगला हिजो अपन नेस परिबे आजी 15 so let it be on 5th 5 तारिख रे फिल हबो तो 5th of May 2025.
Item 5.
Last occasion, your lordship asked me the questions as to whether filing of the earlier repetition, which was dismissed, the present repetition is maintained. I have submitted it to the Lordship order 9 goes, but I am not fully prepared. The Lordship may kindly take up this matter on 21st.
Mr. Dipali Mahapatra, Client Counsel appearing for the petitioner, seeks some more time to present the case, put up this matter on 21st,
21st.
21st of April 2025. Yes.
Item 6.
Along with the
Again.
connected with petitions, yes.
Last occasion we got directed to file affidavit. Respect number 1 is affidavit.
What affidavit we asked you to file?
Chief Engineer S.C. Railway.
What you have stated in your affidavit?
My lord. Report number
Have
1
you given a
already.
copy?
Well, it's at page 11.
Regarding
It is already
appointment of
approved.
arbitrator.
My lord, it is already approved by the opposite part number 1 at page 11, kindly see. Note number 23 dated 9/10/2024, and thereafter note number 24. Next, page 11.
Approve the appointment
already
of
approved.
proposed by the sponsor.
My lord. Thereafter, in inclusion 4, there are 2 communications. First is mail communication to the additional chief secretary,
Yes,
revenue.
Adequate compensation. Ask the authority to appoint an arbitrator in accordance with the rules.
So if you come to the order dated 13/2/2025, you'll find that the learned counsel for the petitioner placed Rule 3 of the Land Acquisition Special Railway Project Rules 2016, which indicate that the central government shall by notification appoint an officer of the rank of gazetted officer of the state government as arbitrator for the purpose of subsection 6 of so and so. So, what is that notification?
Notification.
That is the reason why we asked you to produce the copy of the award of compensation, so also the notification issued by the central government, if any.
So you have proposed for nominating the arbitrator as Collector D.M. Jharsuguda and Sundargarh,
So
respectively.
that should not do unless
unless it is accepted by the government.
Inclusion 4 is the communication.
Annexure?
Inclusion 4, my lord.
Inclusion 4.
My lord. Page 12.
Appointment of Collector and D.M. Jharsuguda.
Page 12.
The additional
arbitration of to the section
chief secretary, revenue and disaster.
Oh. This has come on 6/4/25.
Communication is up to 4. There
This is addressed to the Additional Chief Secretary, Revenue and Disaster Management Department. So,
But if 7th के इथलं लिखायचं the same मध्ये approved by the railway higher authority.
so this is dated when? This annexure enclosure 4 is dated
6/4.
Science
Sorry.
6/4, but it is 2/4 the communication is
ଏବେ
6/4.
ତାପରେ ଆପଣ you take
Next.
instruction about the follow up action taken କାରଣ notification ଟେ ଦରକାର ସିଏ ତାଙ୍କ କାମ ସାରିଦେଲେ ସେ
Because this proposal has to be assented by the Additional Chief Secretary. Without that, how a collector will assume the charge? No.
well, there is to be notification.
Yes,
There is to be
notification has to
notification of the government.
You may propose, but notification has to be there.
Take instruction. You have received this affidavit.
Yes, now.
All right. You have also received. In terms of the order dated 27/3/2025, Chief Engineer, bracket A, CON-2, bracket M, AC Railway, Garden Reach, Kolkata, has filed an affidavit on behalf of opposite party number 1, wherein it is stated as paragraph number 4 and 5. Enclosure 4 of the affidavit indicates that the Deputy Chief Engineer, CON, bracket Jharsuguda, from competent authority for land acquisition, has addressed the letter dated 6/4/2025 to the Additional Chief Secretary, Revenue and DM Department, Government of Orissa, Bhubaneswar, regarding appointment of Collector and DM Jharsuguda. Collector and DM Sundargarh towards arbitrator for the land acquisition of special railway projects. Copy of the affidavit has been served on the Land and Council for the state in source from the Land and Council for the petitioner. The Land and Council for the state seeks some time to obtain the status of the recommendation made in the later dated 6/4/2025 under annexure enclosure 4 of this matter on the commencing from 12th May 2025. This is taken on the board.
Item 7.
In this case, your lordship will kindly see the order dated 19/2/25.
So have you gone through that order?
Yes, my lord, I have gone. You send the letter, my lord. I have not received the instruction, my lord. I have
Yeah,
sent the
this
letter.
order was passed on 19/2 and thereafter
Hundred-
you have taken time on 2 dates. That is on 10/3 and again on 24/3/25.
And the Tahsildar is Kotak order.
ଗୋଟେ ଷ୍ଟାଟସ୍ ଟେ ମଗେଇବା ପାଇଁ ଏତେ ସମୟ ଲାଗିଯାଉଛି ଆପଣଙ୍କୁ KLC number 109 of 2016 ର
my lord.
Hasmal lease case report number KLC number 109 and Tahsildar is not responding or କଣ ଆପଣ ଚିଠି ଲେଖିଛନ୍ତି ତାଙ୍କୁ?
ରାଷ୍ଟ୍ରପତି କୋର୍ଟ
Yes, letter to my lord. Let it come next week. I'll 25th March letter ଯାଇଛି. The topic.
This letter has is dated 7/12/2017. Sorry, 4/12/2017, which is addressed to the Tahsildar Sadar Cutter by Assistant Collector and personal appearance करियो कि अपन को जदि response करूनांती से सुनुनांती ताहले let him come with that case record so that we are keeping it next week.
My lord.
So look on this on 19/2/2025 when the matter was taken up for the first time, we asked the London Council for the state to obtain instruction from the Tahsildar Sadar Cutter opposite party number 5 regarding the status of Hasmal lease case, that is KLC number 109 of 2016. And thereafter, the case has suffered 2 adjournments, that is on 10/3/2025 and 24/3/2025. But the Land Council for the state has not yet obtained instruction as per the order dated 19/2/2025. Land Council for the state seeks some more time in that respect, put up this matter on 22nd of April 2025. दीपाली महापात्र Land and Council for the petitioner is present कर दे वो करें.
Item 8.
No, please, ma'am. Petitioner in this case seeks for a direction to opposite party number 1 for issuance of NOC for his unit minor at Chaudhwa Industrial Estate, Chaudhwa. In the year 1996, he applied for the leave and that was allotted to him by the annexure.
Come to your date chart.
On 16/1/97, LIDCO allotted a plot number 36 to 41 and 48 to 53, measuring 2 acres with the petitioner. On 27/9/97, lease deed for outright payment was issued in favor of the petitioner. And he has also took over the possession of the land and started the industry. On 15/9/22, request letter of the petitioner for the relevant papers with regard to, because that was missed matter. That was with regard to Messrs. Jain Petro Engineering. On 23/23, the account position of Messrs. Jain Petro Engineering with opposite party number 2 was intimated to him by annexer 5. Your Lordship, kindly turn to annexer 5.
So what is the violation in it?
How valuation, my lord? 20 lakh something or
Now, why have you come in rate?
392.
Why have you come in a rate?
My lord,
What is the violation?
My lord, I am ready to payment, but I require only 2 installment for payment, my lord, for which the electric supply has been cut off from my industry.
So,
I want that connection should be made, and I will pay the money whatever required.
who are the parties?
Party, my lord.
Only OSFC and IDCO.
IDCO, my lord.
IDCO and OSFC.
OSFC.
So who has disconnected your supply?
My lord, on the order of the opposite party number 1.
Yes. So you have defaulted in your repayment.
Repayment.
Huh.
I am ready to pay, but only 2 installments, maybe 3.
Have you approached the authority?
My lord, I
What
have
is that?
annexure 6, my lord. I have approached. On that basis, my case was considered, and they have stated that you advise your client to pay the money, my lord.
Yes.
That I am ready to pay. My lord, I am ready to pay only 2 installments. Your lordship may fix.
No, did you pay for 2 installments?
My lord,
Did you pay the authority for 2 installments?
I pay, my lord, I am ready to pay. Your lordship,
Did you pray for it and they have rejected it? That is why I put to you, why have you come in the read?
My lord,
what is the violation in it?
There is no dispute, man. Nothing, there is no dispute. I am admitting
everything is admitted. The only question is, had you made a prayer before the authority?
For 6, my lord.
What is that? What is your prayer there?
As page 28.
What is your prayer?
My prayer
to allow you 2 installments.
My lord,
Kindly
I am ready to pay. But
again, you are ready to pay in 2 installments and that is rejected. Then only you can come.
Well, they have not rejected my prayer, my lord. Only direction we give.
So which action is to be challenged?
The prayer is to issue the NOC at the earliest to facilitate supply of power to unit, and you assured to clear all the dues.
Yes.
So that's not.
You make a prayer before the authority that the entire amount, whatever as is being admitted by you, will be cleared in 2 installments. If they do not agree or they reject it, then only you can come.
What is that outstanding dues according to the?
My lord, 20 lakhs. They have stated.
Yes.
Annexure 5.
And that is since long pending now. 20,37,390.
Where is that?
Annex 5.
No, 5 amount of what like
Last
Uh,
one. 6.
6.
The accounts position of your client, Mr. Jan Katak, as on 31st/3/2022 is 20,37,000.
So you make a proper representation. This representation which you have made or later which you have written on 5/12/2023, that is not here and there. Whatever submission you are making, if you would have made such a representation mentioning all the things, you could have got a favorable response from the authority. But
how can you get this direction? Can we pass a direction to issue NOC without the payment?
Your Lordship may direct
What is the violation?
I will file a fresh application, my lord. That should be considered within that. That may be.
You file it.
File it. The writ petition has been filed by the petitioner, Usman Ali Sheikh. For direction to the opposite parties to issue necessary NOC on leasehold properties of the petitioner at Industrial Estate, Chaudhwa, situated on plot numbers 36, 41 and 48 to 53, Khata number 15017 in Revenue Moja, Gopalpur and Chattisa with an area acre 200 decimal. It appears that the petitioner was asked to clear by letter dated 23/2020. So the petitioner was asked to clear the outstanding dues of rupees 20,37,392 to OSFC to facilitate issuance of NOC in its favor. A submission was made that the petitioner is ready and willing to clear such amount in 2 installments. When we made a query to the Land and Council for the petitioner as to whether any representation has been filed before the concerned authority in that line, the answer was negative, and the Land Council for the petitioner seeks permission to withdraw the petition to oppose the authority by filing appropriate representation in that line. Accordingly, the petition is it is up to you. We can file it tomorrow. What is there? The order will be uploaded today. No, you are not filing any representation.
In absence of that, how can you?
And you cannot pass
unless
order
the
in vacuum.
application is there.
Yes.
Item 9. Lordship, in this, the petitioner number 2 has died. They filed a substitution application and it is well within the time.
IN number
5395 of 2025.
Is it 5395 or 5295?
593.
593.
5395.
What is the death certificate? And what is the legal aid certificate?
File.
This collect those two documents and file it, okay?
Yes, sir.
IN number 5395 of 2025. This is an application under Order 22 Rule 3. Rule 11 of the CPC for substitution of the deceased petitioner number 2, Bashanti Bhattacharya. It is state in the application that Devi Prasad Bhattacharya, who is the son, and Rani Bhattacharya, who is the daughter of the deceased petitioner number 2, is substituted as petitioner number 2A and 2B. In the averment has been taken in the interim application that the petitioner number 2 died on 12/3/2025, and the petitioners Devi Prasad Bhattacharya and Rani Bhattacharya and the so and so are the legal representatives, being the son and daughter of petitioner number 2. Let the land council for the petitioner file the death certificate of petitioner number 2, so also the legal heir certificate. Put of this matter
Continue.
when we are bringing it on 5th of May 2025.
And copy may be served.
Let a copy of the interim application be served and council for the state.
Madam, moreover, because as per the noting in the computer, that is the INR 5295. But the petition copy that is so that 5395.
No, don't go by that. That is 539.
5395.
As you add the
Perfect. That is it.
No.
You also place an interim order at
What interim order is that?
Status quo is on date is there.
1517.
Till the next date it was there.
IN number 1517 of 25. Status quo order. Passed on 10/3/2025. Shall continue till next date. Yeah.
Item 10.
Fine. So after the court, it was the latest position of the FAO pending in the RFA pending in the Court of District Hospital. Annexure 6 page submitted. Up to the date, 3 December is there. By instruction in the meantime, the opposite, the respondent number 7 has been set expertly, and the respondent number 2 is furtherly after the court that we are not interested in that.
Yes, in any case, when the matter is sub judice, you have to take the panel. What is the status of that?
I want to publish the status.
The learning council for the petitioner seeks for an adjournment to obtain instruction relating to the status of RFA number 19 of 2024 pending in the Court of Learning District Judge Jharsuguda. Keep it up your phone. Asked, is this matter will be commencing from 5th May 2020?
Item 11.
I pray maybe taken 2 weeks after Mr. Patnaik was in difficulty.
A mention is made on behalf of Mr. Santosh Kumar Patnaik, senior advocate for adjournment court of this matter. केबे रखो अच्छा court of this matter छुट्टी पर on the ground of his ailment is this matter छुट्टी पर रख दो first victim छाड़ दो second
Item price.
Zealous metro value. My answer is pending. Order answer is pending before open number 4.
yes Mr.
My zealous metro value. My answer 3 pending before open number 4.
What is that annexure?
Representation.
What representation?
My lord, we pray for providing a land, urban land, at least as we are very poor and depending upon friendly with us.
No, representation में कौन land settle हुई?
My lord, there is application. We have also made a separate application on the annexure 2 my lord, series.
When you submitted that?
My lord, that page 23, my lord, 22 review, separate application. Then we made a last recommendation on 12/12/24.
No, ଆପଣଙ୍କର ଏ reputation 5C କରିଛନ୍ତି
3 persons, my lord.
3
Those
persons.
who have made application before the consular, they have also approved it.
ठीक ଅଛି where is your representation by application?
My lord, Mr. 3 man.
हाँ
Annexure 3 टा कौन? अरे application in proper form is there or not?
My lord, annexure 2 is my lord proposed.
annexure 2 series.
My lord.
So why all of you have come in one writ petition?
My lord, they are very poor person, my lord.
ଆପଣ ତିନି ଜଣଙ୍କର ଜମି ଦରକାର ତିନି ଜଣ separate application ଦେଲେ under the relevant provision.
So
ଗୋଟେ writ petition କେମିତି ପଳେଇ ଆସିଛନ୍ତି?
my lord, they have submitted one day. That's why.
ବରା କହୁଛି ଆପଣ ତିନି ଜଣଙ୍କର ଜମି ଦରକାର ତିନିଟା application ଦେଲେ ଗୋଟେ ଦିନ ଦେଲେ whether one writ petition is maintainable because the consideration may be different for different person. So procedure has to be taken in respect of each application differently. How you are
Yes, several writ petitions.
ଆଗରୁ କେତେଟା writ petition ଆସିଛନ୍ତି
ଆଗରୁ ଦିଟା ହଜୁର ଆସିଛି
କଣ ପାଇଁ ଆସିଛନ୍ତି?
ସେ ଗୋଟେ ଆଜ୍ଞା ଏନକ୍ରୋଚମେଣ୍ଟ କରିଥିଲେ ଏନକ୍ରୋଚମେଣ୍ଟ ନୋଟିସ ଦେଇଥିଲେ ତା ଏଗେନ୍ଷ୍ଟ ଆସିଥିଲେ ଆଉ ଥରେ municipality authority trying to evict us
On the self-same land. Then
So what is the orders of these
order, my lord? Even to the one is the collector is same is pending, my lord. Another is
no. This court, as you have mentioned in the cause title, that there are 2 writs you have filed.
My lord.
So what is the order which was passed in that 2 writ petitions?
Order, my lord. I also mentioned the date of disposal, my lord.
no orders.
Orders have been passed.
Order, my lord. Orders, both the orders.
I find those 2 orders. Let us see that. You are appealing for whom?
My lord, I want to say something because earlier this petitioner filed a writ application before this honorable court. That was this disposal directing to every date with due procedure, my lord. They are blocking in front of my house, my lord. That's why I have filed a suit before the civil judge, my lord. And
you are intervener.
Yes, my lord. I want to intervene. May I submit the document, my lord, civil court judgment? All the petitioner are opposite party, my lord, respondent in this case.
So the particular land which
that land, my lord.
That particular land has been with the subject matter of that civil suit.
Yes, my lord.
And what order has been passed in the civil suit?
In the civil suit, my lord.
You be evicted in due process of law.
My lord.
You are in possession of the land and you have been asked.
They are occupying in front of frontage of my house, my lord.
So who has been asked to be evicted? You have been asked to be evicted in due
No,
process
no,
of
no,
law.
my lord.
They have been asked.
They are
Ah.
been asked.
Have you challenged that
Uncle,
order?
why have you come there?
Then
But
how to-
I have not any objection against him, my lord. We are residing
All
under
the
the law and
petitioner
land.
Still he says that the very land
Come up,
for
please.
which you want settlement, that is the subject matter of the
I have,
civil suit.
we have not any demand nor any
You are
demands
a
against
party
him,
in
my
that you are a party in that civil suit.
my lord.
Plot number 2060 under
No,
Khata
no.
number 4.
I have also annexed the ROR, my lord, under answer
Ever ଅଛି same plot ଅଛି?
ଅଛି.
ଅଛି ତ if you are agreed, so this order has been gone against you.
And you are suppressing the fact
You
also.
are not telling anything. The intervener has come forward. The defendants are directed to remove the construction over the suit land and to restore it to the prior position, so and so. So, if you are agreed to challenge this order, it is the
My lord, that is
civil suit is disposed of on 15/1/2025.
my government land, my lord.
Again, you are not able to understand clearly. So what? Government land, you will
Government
continue.
land, he has not any location to make us vacate, my lord.
Challenge that order. The civil court decrees in his favor in respect of that land. That's one. The petition has been filed with a prayer for a direction to the opposite party number 4, Executive Officer, Bargad Municipal Council, to take a decision on the representation as well as application for settlement of the government land in favor of the petitioners, as well as alternative residential arrangement for the petitioners. What is your application for intervention?
My lord, I filed in course of day, my lord, because
How you are to first file an application
my
for
lord, if
intervention.
your lordship permit, in course of day, I filed, my lord.
What is the permission necessary? You are to file an application for intervention.
Today I am.
Give a copy. Without
See,
filing that, you are directly filing.
No,
this
no, no,
document.
my lord, I want to file intervention application.
Acha. You are Mr. Dilip Kumar Sahu.
My lord.
Dilip Kumar Sahu, Grand Council.
My lord,
submits,
I filed wakalat.
you file an intervention application
My lord.
with this, submits that, and he wants to file an intervention application in this writ petition, as the petitioner has suppressed regarding suppressed that the land for which he wants settlement is the subject matter of a civil suit in the Court of Civil Justice Senior Division, bracketed WC, Bargad.
I have also mentioned, my lord, para 5.
Just a minute. That is his submission. Civil suit number 49 of 2020. And by judgment and order dated 15/1/2025, the civil suit has been disposed of, and the petitioners were directed to remove the construction over the suit land and to restore it to its prior position within 3 months. Failing which, the proposed intervener will be at liberty to execute the same through the process of law. And the petitioners were permanently restrained from creating any disturbance in the peaceful use of the suit land, as ruled by the plaintiff, either by continuing any construction or by obstruction. The Land Council submits that he will file the intervention application during course of the day, and a copy of the same shall be handed over to the Land and Council for the petitioner, and also the Land Council for the state. Put of this matter in the week commencing from 21st April 2025. If any intervention application is filed, the same shall be placed on record. ଏଇଗୁଡାକ ତାଙ୍କୁ hand over କରିଦିଅନ୍ତୁ, ସେଗୁଡା file କରିବେ ଦଶ।
Item 13.
For the petitioner. In this case, land of the petitioner was acquired for the purpose of national house, and the ROR and the ROR the of the over which the area in which the land was acquired for the national purpose, for the purpose of national highway is annexed 1, and in the annexed 1, total area was acquired, and
What is your grievance?
the compensation was initially awarded under annexed 2 series.
Yes.
But that compensation was erroneous. In spite of our grievance,
You want the compensation at a higher side?
no, my lord, as a proper way. What is the
compensation ଟା ବଢିବା ପାଇଁ ଚାହୁଁଛନ୍ତି ନା ନାଇଁ କମିବା ପାଇଁ ଚାହୁଁଛନ୍ତି? ବଢିବା ପାଇଁ ଚାହୁଁଛି।
which is the appropriate as per law.
So National Highways Act ର କିଛି provision ନାହିଁ ଯଦି ଆପଣ compensation जो amount determine ହେଲା, if you are dissatisfied and claim for higher compensation.
Appeal provision is there.
No.
देखिए
3G5 टर नहीं की।
Appeal has been filed, but
ଆଣିଛନ୍ତି National Highways Act ଆଣିଛନ୍ତି?
national
ଆଣିଛନ୍ତି ବହି ଆଣିଛନ୍ତି ନା ସବୁ ମୁହଁରେ ଅଛି?
I have mentioned the provision.
ବହିଟା ଗୋଟେ National Highways Act ଉପରେ ଆର୍ଗୁମେଣ୍ଟ କରିବାକୁ ଆଣିଛନ୍ତି, ବହିଟା କାଇଁ ଏଠି? Read.
3G5
3G5 कहला, if the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall on an application by either of the parties be determined by the arbitrator to be appointed by the central government. And have you approached the authority?
Seven man improved order of the arbitrator court or appellate court.
So arbitrator you have approved and the arbitrator has decided the matter.
Madam.
What arbitrator has held?
No, in the final period the portion of the improved order.
Read the order in Toto.
This case is put up today. Our Law and Council appearing for the petitioner on the merits of admission of the arbitration petition. Law and Council submitted that due to imposition of stay orders, the revised benchmark valuation (BMV) by the Honorable High Court of Orissa, the market value of the acquired land has been determined by the CALA land acquisition, taking into old BMV at the rate of 1,35,500 per acre. It is argued that after vacation of stay order, the petitioner is liable to get the market value of the acquired land according to the revised benchmark valuation at the rate of 1,80,000. 1.80 lakhs per acre. In support of claim of market value at the rate of 1.80 lakhs per acre, land advocate exhibited a copy of information obtained under RTI Act from sub-register of Karanjia by the inspection number 300 dated 24/5/2022. The report of CALA from Tahsildar Karanjia reveals that as per the BMV of Mauda Durgapata received from the sub register Koranja under category 2. Land, the market value of the acquired land has been determined at the rate of 1,42,500 per acre. It is in this context, the information obtained by the petitioner from the PLO sub-register office Karandia relating to the BMV of acquired plot market district of Moja Durgapata for the period of from 23
All right,
May.
so arbitrator has dismissed it. So if it is dismissed, then the say 3G6 says that the Arbitration and Conciliation Act shall apply. So that provides an appeal to be preferred. ଦେଖିଛନ୍ତି Arbitration Act.
Arbitration Act
Arbitrator
ଯେହେତୁ
order
appeal ଟା
against
ଫାଇଲ ହେଇଛି arbitration provision ରେ
କାଇଁ appeal କାଇଁ?
ये केस नंबर ता एले arbitration केस नंबर
Oh,
This is 8 of 22 is disposed of.
ତା against ରେ appeal lie କରିବ the arbitration.
arbitration I mean
Thirty-four.
Setting aside. Setting aside of the word. 34.
Arbitration arbitrator order against ରେ appeal lie କରିବ. ଆପଣ read କୁ କଣ ପଳେଇ ଆସିଲେ? If you have got the alternative remedy.
and the impugned order date of impugned order was 10th November 2022.
अच्छा डिले जदि ହେଲା ଆପଣଙ୍କର जो टाइम भिତରେ अप्रोच करवा कथा appellate authority को यदि you can file an application there if the provision is there for condoning the delay.
And delay may be condoned.
We'll delay. We'll condone the delay.
What are you saying, sir? Application we will condone the delay.
You have not made an application before the proper authority. Now you are coming in late. What is all going on? Disgusting.
You withdraw it to approach the appropriate authority. ନାଇଁ ଆପଣ ପଢନ୍ତୁ କାଲିକି ଆସନ୍ତୁ ପ୍ରୋଭିଜନ ଦେଖନ୍ତୁ କଣ ପାଇଁ ଆସିଲେ ପୁଣି କାଲି ସକାଳେ ଆଉ ଗୋଟେ ରିଟ୍ ଫାଇଲ୍ କରିଦେବ ନା ଏମିତିଆ କେସ୍ ଆସିଲେ ନିଜେ ଦେଖନ୍ତୁ 3G56 କୁ ପଢନ୍ତୁ ତାପରେ Arbitration Conciliation Act ପଢନ୍ତୁ you get satisfied that there is a provision for appeal in such type of case ହେଲା କାଲିକି ନବା ଆମେ put up this matter tomorrow.
Present for OP number 1 maybe ma'am.
As paid for by the land council for the petitioner. Land council for the opposite party number 1 is present. Yes.
Item 13.
Item 13 on behalf of Mr. Subudhi kindly taken up next to that. That's some emergency medical issue item. That's right.
Please give the name. A mention is made on behalf of Mr. CHITTARANJAN Subudhi and counsel for the petition for adjournment. Put up this matter. Keep care of you out.
Next week or
Next week. All right. Put up this matter. 22nd of the 22 तारीख दिन. 22nd April 2025. Yes.
Item 15.
Land was acquired. Land of the picture was acquired for expansion of NH20 Miller. And your lordship mechanic annexure 2 compensation was assessed. Page 11 annexure 2. Compensation was assessed for an amount of 72,77,695 rupees, and notice was issued to submit all the documents. I submitted all the documents. And annexure 3 your lordship mechanic
An amount of 19,07,843 was transferred to my account at page 13. Annexus 3, page 13, my bank passbook. And the balance amount has not been paid. No, ସେଇଟା total ବିଭିନ୍ନ land ପାଇଁ ହେଇଥିବ ନା କାଇଁ amount ଟା କାଇଁ amount ଟା Annexus 2 ରେ
Notice.
Annexus land schedule ଟା ବି ତଳେ ଶୁଣନ୍ତୁ ଟିକେ ଭାଇ amount ଲେଖା ହେଇଛି
70.
ଏ ସବୁ ତକ ଜମି କଣ ଆପଣଙ୍କର? ହଁ ମୁଁ ପଟାଟା ଦେଇଛି ସେଠି Annexus 1 ରେ ପଟାଟା ବି
ଗୋଟିଏ ଖାତା
ଗୋଟେ
ତିନିଟା ପ୍ଲଟ
ଗୋଟେ ଖାତା ତିନିଟା ପ୍ଲଟ ପାଇଁ ଆପଣଙ୍କର
72
ସାହାଯ୍ୟ କରାଯାଇଛି କାଇଁ ଫୁଡ ଆମାଉଣ୍ଟ ଟା ଦିଆହେଲା ଉପରେ ଏଠି ସେକେଣ୍ଡ ଲାଇନ କୋଉ ପେଜରେ ପେଜ 11 ପେଜ 11 ନାଇଁ 11 ନା ତ ମୁଁ
ସେଇଟା
ଦେଖିଛି
ଏ ଯୋଉ
ଆପଣ
ପାସବୁକ୍
ପାସବୁକ୍ ପେଜ 13 ରେ କୋଉ ଲାଇନ ଟା କହିଲେ ପେଜ 13 ଲାଷ୍ଟ ତିନିଟା ଏଣ୍ଟ୍ରି ଅଛି 4,09,436 ଗୋଟେ 6,60,788 ଆଉ ଗୋଟେ ହେଲା 8,37,619 ଟୋଟାଲ ହଉଛି 19,07,843.
So the last amount was entered on 5/12/24.
5/12/2000.
On the very day, all the three amounts happened.
Sure. Thereafter, for Annex 14 or not, page 14, Annex 4. I intimated them that only 19 lakh has been credited and the balance amount. ସେମାନେ କିଛି କଲେନି so land acquisition officer so on so on so you have to obtain instruction or the NHI should be participated NHI notice you is the opposite party that is the only land action officer from authorized signatory NHI he has to disburse that amount ये disbursement ये तो आपको authority है National Highway. Achha. NHI, have you given a copy to the notice? Listen. This writ petition has been filed by petitioner S.K.Sahoo with a prayer for a direction to the opposite party for disbursement of the entire compensation amount of fees 72,77,695 after deducting the amount already paid with interest at the rate of 9%. The learned counsel for the petitioner submitted that the petitioner is the from the ROR it is evident that ROR under annexure 1 it will be evident that the petitioner is the recorded owner of High Court number so and so paragraph number 3 is right. The plot number so and so under khata number so and so annexure 2 were acquired for expansion of the national highway number 20 and the petitioner was noticed by notice dated 14/3/2023 to receive the compensation amount of rupees 72,77,695 and to submit all the required documents. It is the case of the petitioner that even though all the required documents were submitted before the opposite party number 1, only 19 lakh code elections amount of 19 lakh 7 code elections. Total petition code election. Page 4, para 7. Para 7. Only 19 lakh 7,843 was credited to the bank account of the petitioner on 5/12/2024. And for the balance amount, even though the petitioner has submitted a representation under Annexure 4, but on 22/1/2025, but the balance amount has not been credited in her account. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice by speed post with fee for plausible shall be filed during course of this week. Matter be listed on 12th of May 2025.
Item 16.
Yes.
One repeated got legal grant by the total case number 363 of 16 by the Tahsildar homes. So after the restricted period, he sold the land to one Indumati Mahal.
What is your prayer in this, sir?
My prayer is that one of the purchaser, so two other purchasers, so their land has been settled in their favor. So in spite of after by the Annexure 7 measures, Annexure
The order in this case has been passed, which is under challenge in this writ petition, is of the year 2013.
No.
After how many years?
I have done this application.
Yes.
The Honorable
In 2010.
Directed me to appeal for the Tahsildar.
Yes.
So I made an application that is by the Annexure 51 page.
Yes, what happened?
So that is still kept pending and inspect my repeated approach.
In between, the reference which you have made before the Tahsildar regarding WPC 12987 of 2006 has already been disposed of by the Supreme Court in Salila Patnaik case.
In that case,
all cases have been disposed of.
The land has been settled in favor of Salila Patnaik.
That is all set aside.
So I may give me a chance. Let me you think to me.
You are not aware about that?
No, I do not know. Supreme Court decision is problem actually.
Supreme Court decision is remand in matter asylani court. How individual case to देखियो पाएं order age.
So another date can be given so that the verify all the things what will happen.
It is the order of Tahsildar, no earlier order?
Earlier order Tahsildar, that is the 29/2006.
Where is it?
Annexure 7 minor. At the page 49.
Tahsildar order to?
Tahsildar order. ସେଥିରେ Salila Patnaik ଅନ୍ନପୂର୍ଣ୍ଣା ତାଙ୍କ ଏଗ୍ରିମେଣ୍ଟ ଲାଣ୍ଡଟା ସେଟଲ ହେଇଗଲା ତାପରେ ସୁପ୍ରିମ କୋର୍ଟ ଜାଣିନି ତାଙ୍କ ସେଟଲ ମୋର ପ୍ରେୟାର ହଉଛି ଯେ ମୁଁ ପର୍ସନାଲି ମୋ ଲାଣ୍ଡଟା ସେଟଲ ହଉନି that is my only grievance.
It is pertinent that the report says that during my spot visit with RI, it is
page 49.
Nag has transferred the land and not in possession.
So that is a disputed complete. Even if it is there, it's a disputed question of fact. You need to declare your title. Other aspects are also there.
Why not?
You purchase the land from Indumati Mahanti, as that appears from that representation which you have made to the additional sub-collector under Annexure 8.
I purchased the land.
Yes.
Annapurna and Salila also purchased land.
Yes.
So after purchasing, so they found that the lease has been cancelled. Now they came to the Honorable High Court.
Yeah.
Honorable High Court, by the order at page 30 and 35, cancelled the order of resumption. So thereafter, knowing this, that Salila and Annapurna the opposite Tahsildar, and the Tahsildar scheduled that in their favor. So
Where is that? Where is that order?
that is at page 49, my lord.
Page 49.
Council order,
No, no, it is long before that. No, no.
Council order, that is order.
ଏଇଟା ନୁହଁ, ଏଇଟା ଆପଣ କେବେ କହିଲେ ସେ ଯୋଉ ସେଟଲ କଲେ ଅର୍ଡର ପରେ ପରା ହାଇକୋର୍ଟ କୁ ଆସିଲା ପରେ
ହାଇକୋର୍ଟ ତ my lord.
ହଁ ଆଉ ତାପରେ ସେଟଲ ହେଲା ବୋଲି କହୁଛନ୍ତି।
Council order 2006 ରେ order କଲେ in my favor. Council order 2006
ମାନେ ରିଜମ୍ପସନ ଟାକୁ ଯୋଉ କ୍ୟାନ୍ସଲ ହେଲା ହାଇକୋର୍ଟ ଅର୍ଡର ରେ where is that?
ସେଟା
ସନିଲା ଆଉ ଅନ୍ନପୂର୍ଣ୍ଣାର
4/10/2006
4/10
2006 ଆଉ 19/10/2006 there are two interpretations.
where is the order?
That is Annex 5 series, my lord.
ତାପରେ କଣ ହେଲା?
ହେଲା ପରେ notice that I owe to the RA office and I told him that he has been cancelled. So I approached the Honorable High Court. Honorable High Court directed that I have to appear before the Tahsildar. So then I filed that petition Annex 8, my lord. So that is still pending.
It is on the basis of a direction of this court you have approached the Tahsildar.
My lord.
Where is that order?
Just 1 minute. With 37.
Yes.
37.
The order is 25/2002 that land has been reduced. That is the page 46 and 47.
That is
39 is the relevant order dated 13/12/2010, wherein it is stated that we set aside the order dated 20/5/2002 passed by the additional Tahsildar Bhubaneswar in WL case number 363 of so far as it relates to the petitioner and direct the petitioner to appear before the Tahsildar on so and so date. Tapre Tahsildar shall fix a date of hearing, proceed with the matter and take a fresh decision so far as it relates to the resumption of the land of the petitioner in terms of the so and so. So you approach the Tahsildar. So what happened then?
It is pending.
This is the letter dated Annex 2. It is 2013 letter. So what you are doing for the last 12 years?
after approaching the Tahsildar.
No. The date is 17/1/2013. So how can you say that no action has been taken on the basis of the order and on your representation till date?
Repeatedly, I went to the office of the Tahsildar, and they are not even taking any step, and they are not even hearing me in this matter.
So you should file a contempt. You're right.
Very last.
Direction of this court has not been acted upon.
My lord.
Instead of contempt, why did you come in?
The direction was that I would approve the Tahsildar.
Yes, you approached.
I approve the Tahsildar.
And they are not acting.
They are not.
Another read.
Instruction about the status of this application which is submitted. There is a judicial order also in the favor of the petitioner that he has to be given an opportunity, and he has already approached as it seems. This petition has been filed by the petitioner, Srimati Minati Gupta. For a direction to the opposite parties to record the name of the petitioner ROR, which was purchased by the petitioner. it appears that the petitioner earlier approached this court in WPC number 17809 of 2010, challenging the order dated 25/2002 passed by the additional Tahsildar Bhubaneswar in WL case number 363 of 1969. And this court by order dated 13/12/2010 has been pleased to set aside the said order and directed the petitioner to appear before the Tahsildar Bhubaneswar so that Tahsildar shall proceed with the matter and take a fresh decision relating to resumption of the land of the petitioner. In terms of the order dated 19/10/2006 passed in WPC number 12987 of 2006. The Learning Counsel for the petitioner submits that in pursuance of such order, the petitioner approached the additional sub-collector Bhubaneswar and filed a representation on 17/1/2013 to pass the appropriate order in case number means consider WL case number na consider WL case number 3779 of 2012 regarding plot number 259/1314H to record the said plot in her name, and thereafter she is repeatedly approaching the additional sub-collector Bhubaneswar for such purpose, but no action has been taken by the opposite party. Number କାହାକୁ approach କରୁଛନ୍ତି ଆପଣ additional ତହସିଲଦାର ଲେଖିଛନ୍ତି ମାନେ opposite party number 5 opposite party number 5. Let the Land Council for the state obtain instruction about the status of the application under Annexure 8 put of this matter moving comments from 12th of May 2025. We are just coming with
Item 17.
Lordships, Lordships order, previous order, I filed the
So each of the persons are different in qualifications also.
May I?
Yes.
Pursuant to the order dated 24 to 25, petition has filed an affidavit that has not been tagged to my file. Can I pray for tomorrow or day after?
That has come on record.
That
Yes,
is on
It
record.
has come on record.
Fact 10.
It is not with you.
It's not with me.
Let
That
it
is a
come
fact.
tomorrow. She is not having that affidavit herself. Right?
Can I pray for day after tomorrow?
All right. The learned counsel for the petitioner, Mr. Hutta, has filed the affidavit in terms of the order dated 24/3/2025. The learned counsel for the state submits that the said affidavit has not been tagged to the file and the matter may be taken off day after to
Day after.
put up this matter on 17th April 25.
Item 18.
In this case, your lordship will kindly see the order dated 4/4/25, wherein your lordship has directed me to file an affidavit.
Where is that affidavit?
I have filed my lord on Friday.
But it's not. All right. The
Affidavit
party.
ଅଛି.
Asiyo record.
Al-
Ordinary. Asiyo. You have got that. We are coming.
ଏଟା ଇଡକୋ against paper.
अच्छा, state of
State is
Orissa
the party.
package है ना?
State is the party.
Give a copy to in terms of the order dated 4/4/2025, the learning counsel for the petitioner has filed an affidavit today and I approve file କରିଛନ୍ତି
Right.
ଶୁକ୍ରବାର ଦିନ ପାଇବି।
The affidavit copy has been served on the learning counsel for the state in court today. Put up this matter on 17th of April 2025. Yes. Go through that particular order and then this affidavit.
ନା ଅର୍ଡରଟା ମୁଁ କୋର୍ଟ କରିଦେଇଛି।
ହଁ ନାଇଁ ଠିକ ଅଛି ଆମେ ଯୋଉ ଅର୍ଡରଟା ପାସ୍ କରିଥିଲୁ ପ୍ରିଭିୟସ୍
ଆପଣଙ୍କ ଅର୍ଡରଟା ହିଁ
ଠିକ ଅଛି ନେକ୍ସଟ
Item 19.
And on behalf of Mrs. Mahanti, we are filing the counter today for opposite the court.
Which part number? Counter.
Ashok sir.
Huh?
Opposite party, Ashok sir.
No, no.
Similar sir, file.
Oh, only acha. Solo which party?
Kindly, give a short break, Mother.
I'll be kept with something copy of this.
You are appearing for the opposite party. What do you want?
Actually, conducting counsel seems unclear. So we are filing the counter today.
In fact, no notice has been issued. You have so moto entered appearance, but since you have already filed counter affidavit, so we are issuing notice to regularizing the matter. The writ petition has been filed by the petitioners challenging the order dated 28/8/2024 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in way number 561 of 2018, in which the original application filed by the opposite party, S.K.Sahoo, was allowed, and the petitioners were directed to regularize the service of the opposite party retrospectively with effect from 24/7/2002, with a further direction that he would be entitled to all consequential service benefits. And the petitioners were directed to pass consequential order within a period of 120 days from the receipt of the copy of the order. Here is the grounds taken in the writ petition on Mr. Pari and Deputy Solicitor General, along with Mr. Kahana Likhiva,
S.S. Kashyap, Satyasindhu Kashyap,
Satyasindhu Kashyap, London Central Government Council,
Senior Panel Counsel.
Senior Panel Council, issue notice on the question of admission, indicating therein that the matters are disposed of at the stage of admission. Mr.
Yes, yes. Opposite party in court today.
Mr. S. Mahanti, Land Council, was already entered appearance in the case on 4/4/2025, files counter affidavit, which is taken on record. Have you served a copy of the counter affidavit? Let a copy of the counter affidavit be served on the London Council for the petitioners in course of the day. Put up this matter. You go through we'll take up this matter on 5th of May 2025. List this matter on 5th of May 2025. Yes.
Item 20.
May I please, my lord, along with this writ application, another 3 similar applications have been filed before this honorable court. The other writ petitions are filed, the similar writ petitions have been filed, my lord. All the petitions may come together. I have the number of
similar means here you are
all the tribunal order has been challenged by regulation.
No, this is dated 39/2024 order of the Central Administrative Tribunal is under challenge. In those applications, same order or order passed in different way?
Different way, but order is for the regulation from the initial
So
date of
the issue in question what is same.
Yes.
The London Council for the petitioner submitted that though this writ petition has been filed by the petitioner challenging the order dated 39/2024 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 294 of 2019. But similar issues are also involved in WPC number already WPC number so and so, in which the order passed by the London Central Administrative Tribunal in different original application are under challenge, and therefore this petition be listed along with the aforesaid two or three read petition. Put up this matter. It will come 2 weeks after. Put up this matter and we come and change on 12th of May 2025 with WPC number.
I am appearing for the sole opposite party. In similar matter also posted to 5th May.
Hello, one matter is 5th May. I have given the number. So and so files power for the opposite party. Read a copy of the writ petition served on the Land Council for the opposite party during course of this week. Okay. The name of the Land Council for the opposite party will be reflected in the positive stance form. Right?
Item 21.
The regular matter lordship, the rejection of application of the prisoner 28 days posted to 21st
In
of
this case, the impugn order is passed on 4/4/2024 on the ground that the judgment relied upon by the petitioner in the court below, the amount has not been sanctioned. In the meanwhile, by order dated 25/3/25, the sanction has been made. He has to approach the court below again.
So what order has been passed?
It's posted to 21st of this month.
Have you given a copy to the State Council?
Yes.
So there we have just stated that London Council for the State took some time to examine whether
against order passed this.
There is any
that was the order.
Posted to similar matter, posted to 21st of this week.
Again, you have to move.
Kindly see Annexure 5 for
Yes, yes.
Annexure 5 was on.
Annexure.
Please place it.
Yes. Annexure 5 relates to the LAR case number 183 years.
Number
LAR. The order cited by the petitioner just now, it may not be relevant for this case. Because in the meanwhile, by order dated
20th March
25, the amount has been sanctioned.
No. Ya nada huchi Jamuna Niyal.
This is not.
It may be an identical case or whatever it may be.
The order says the London Council for the State seeks some time to examine whether against any order passed by the 28A of the LA Act, if there is any alternative remedy challenge to same or not. Let's force this matter to.
Yes, Mr. Bera.
The application has been rejected on the ground that the LR case number, which has been cited by the present petitioner on the application under section 28A application, the amount has been estimated and submitted before the government for sanction. Due to non-sanction, till date, my application has been rejected on this same ground. Running page 3025, last paragraph reverse. In the meantime, the amount has already been sanctioned. I have also annexed.
Where is that?
Madam?
Where is that?
Annexure 6, running page 27.
The impugn order was a 4/4/2024 The sanction orders of 20th March 2020.
That the ground has which has been taken by the special law, that is not correct, because the amount has already been estimated and submitted before the government.
ठीक अछि वर्तमान तो अमाउंट आसी गलानी ना so what is the problem now you to
No
approve?
application टा से reject कर दी 2024.
They have to approach again.
So you are to approach again. What is the injury?
Your lordship, 28 application within 90 days of the judgment passed by the LR case number 183 of 2010. जो जजमेंट पास कर 90 दिन भीतर एप्लीकेशन अप्लाई कर हमें एप्लीकेशन अप्लाई करना आउ तो 90 दिन हम पाखर ना
So in view of the sanction dated 23/2025, you need to approach again.
28 the land acquisition. Within time, but since that was not sanctioned,
that is rejected.
So now is
my application might have been pending.
Sanction. Can give me in view of Annexure 6.
No, he says that since this 28 application he cannot file because that period has
Now we
expired.
have to give a direction.
But he says that if this
It is
order
already
will be set
sanctioned.
aside,
It is said.
then it is remitted back. Since that sanction has
Right.
been made, he can
in the meanwhile.
pursue the matter.
Right.
What do you say? Suppose why it was rejected because
Sanction was not
the
made.
sanction has not been accorded.
Yes.
So
Not a
therefore,
sanction.
the petition 28A petition was rejected. Now the sanction is there, but he cannot file the 28 application at present because that period of 3 months has expired.
Yes.
So if we set aside the order and remit the matter to the concerned authority
Yes.
in view of
That
that
will-
sanction, that can be
That can-
adjudicated. So that problem of 3 months will not
That-
create
that
any
won't
hurdle.
be.
Right? So look on to this writ petition has been filed by Jamuna Niyal, challenging the dated 4/4/2024 issued by the special land acquisition and opposite party number,
Opposite party number 3.
special land acquisition officer from RRO, Lower Indra Irrigation Project. Kharia. In rejecting his petition under section 28A of the LA Act 1894, which was filed on the strength of the judgment dated 10/2/2023, passed in LAR case number 183 of 2010, disposed of by the London Senior Civil Judge Noapada, on the ground that the estimate in the referred LAR case number 183 of 2010, filed by Puten Maji, has been submitted for kind sanction to Department of Water Resources by the office letter number 978 dated 2/6/2023, but the same had not been sanctioned. The London Council for the petitioner submitted that the Director R&R Additional Secretary to Government by letter dated 20/3/2025 under Annexure 6 has been pleased to sanction the decretal dues amounting to rupees 2 crores 48 lakhs 57,805 towards the decretal dues in compliance of the order dated 10/2/2023 of the Court of Civil Justice Senior Division, Nuapada, in LAR case number 183 of 2010. However, since the petition under Section 28A, which was supposed to be filed within a period of 3 months from the date of award of the court, has been rejected by the Annexure 5, and the petitioner cannot file such petition once again, which would be not entertained in view of the time stipulated under Section 28A of the LAR. The order may be order dated 4/4/2024 under Annexure 5 be set aside, and the opposite party number 3 may be directed to take a fresh decision on the petition filed by the petitioner under Section 28A in view of the sanction of the decretal dues made under Annexure 6 stop. Land Council for the state has no serious objection to such prayer. Considering the submission made by the Land Council for the respective parties, taking into account the grounds for which the petition under Section 28A of the LA Act filed by the petitioner was rejected, and further, the fact that in the meantime, under Annexure 6, the decretal dues has been sanctioned by the government, we set aside the order dated under annexure 5, order
Annexure
dated so
5
and
is
so
a
4
communication to the
2020. Yes,
Annexure 5 is a communication to the AG officer.
what is the AG office?
Yes, sir.
What is the order dated?
Same. 4/4/2024.
Same date is
Yes.
order
So order
dated.
टा नहीं on record देई नहीं
ନାଇଁ ନାଇଁ ସେଇଥିରେ ତା ଦେହରେ କପି କରିଦେଇଛନ୍ତି ନା ଏ ଯୋଉ ଏଇଟା ହଉଛି ଏଜି ଅଫିସ ତଳେ ଦେଖନ୍ତୁ କପି କପି ସବମିଟେଡ so and so for kindly copy to so see he has received the and the opposite party number 3 has to take expressly adjudicate the matter in accordance with law. It is made clear that we have not expressed any opinion on the merits of the 28 application petition under section 28 filed by the petition. Within a period of 3 months from the date of production of the certified copy of the order. I don't like it. So same 22, 23, 24,
26
same order के number उड़ा भी तो अलग अलग case number किसी अलग
same
देखी दो 26 है same
26 है
27 टा कौन
27 your lordship
20
similar order passed by this honorable court under annexure annex running page 22 your lordship.
Annexure 2 28 day application has been pending. File किसी की नहीं, there is no endorsement किसी date नहीं.
application pending ଅଛି
Yes sir.
sanction है ना
এটা sanction ହେଇକିରି ଆସିଛି ନା ଏମିତି application ଦିଆ ହେଇଛି subject to sanction ହେଇଯାଇଛି
हमारा prayer होती only disposal of the my application under annexure 2 below 15 to 23 15/2/2023 my application. Another LR case your lordship as per the judgment passed in
we have stated that if there is no other legal impediment
yes your lordship order I have annexed
ये जो annexure 3 रे जहाँ order pass है ये जो case number उड़ा के उड़ा कोई change कर दी अच्छा ये जो लिखी जाती LAR number वो
30 आप 2007
बाकी सो अब ये जो नुआ पड़ा ये सब समान चेंज कर दी जाती ऑलरेडी ना annexure 3 हाँ alright disposal
of like
Item 28.
So the opposite part number 2.
Who is the counsel for the petitioner?
I am appearing on BC your lordship.
So you have not filed the requisites.
My lords, I have inadvertently filed this writ application instead of an MSA. My lord, I will be permitted to withdraw with a liberty to file before the concerned court.
In appropriate form.
You want to withdraw this writ petition?
Yes, your lordship.
What is your good name?
Madam Satyaprakash Satpathy.
अच्छा मिस्टर सत्य प्रकाश आपण कहाँ पे appear करते OP2 you are Mr. Siddharth Radhakrishnan land counsel for the opposite party number 2 is present. Stop. The land Mr. Satya Prakash Satpathy land counsel appearing for the petitioner seeks permission to withdraw the writ petition to approach the appropriate forum.
Whereas appropriate court, I have to file this in the form of a miscellaneous second appeal.
All right. Accordingly, the writ petition is disposed of. Yes, next.
Item 29.
As we withdraw.
Modification of the order, my lord.
What thing?
Para 3 7th line रे ओटा नाटे रही
16/1/2025 रो. What is it? Paragraph
3 रो 7th line रे ओटा नाटे रही कि look over is no related to the fictional family member. The नाटा से 40.
Legal heir, sir, petition is the legal heir of power.
Legal is the recorded tenant of Khatna 43.
खाली लुकुटा बाहर
The Buluku voter out of
Okay. The IA number so and so, this is an application for modification of the correction of the order dated 16/1/2025. Copy of the interim application has been served on the Land Council for the state. The Land Council for the petitioner submits that in paragraph number 3 of the order dated 16/1/2025, one name, namely Uluku Hui, has been mentioned, and which has got no connection with the case, and therefore the said name be deleted. And counsel for the state has no objection. Accordingly, prayer is accepted. In the third paragraph, the name of Uluku Hui stands. Yeah. It is part of the order depends on order. Yeah.
Item 30.
IA disposed of the them. Yes, sir. Disposed coin the response for petition of surname has been inadvertently typed as once. Order dated. For the same may be read as for example. Adauchi Boronai, Pulakai, that should be Boronai. Next.
Item 31.
May I please, Lordship? I mean, BC, Lordship.
Yeah.
Well, last occasion, Lordship on 6/3/2025 directed me to file an IA to implement the correct designation of the opposite party number 1 and 2.
The order dated 6/3/25 indicates that you wanted to carry out certain amendments in the cost title of the by filing an interim application.
Yes.
So, have you filed that interim application?
Yes, my lord. IA number 5259 of 2025.
5259.
Order number 17.
Pardon, my lord, I am appearing for opposite party number 2 and 4. NHA.
Five two five nine.
17/3/25 का आपके तक कोई दीजिए
733.
17/3. IA for amendment is not available in the record, but a consolidated cost title has been filed. Ajit Patnaik, Land Council has filed local account.
Flag A, my lord. IA is on flag A.
So consolidated cost title is already there. Flag 10.
This application is very much premature. Just about.
We are not hearing on merit, Mr. Land Council. Please wait. The order dated has been pleased to introduce please to directly to the opposite party to name on designation and direction of the mistakes consolidated cost title file here. कहाँ नाटा ठीक से लिखिले?
The consolidated cost title Union of India referring to its project director, and this correct. 143 NH and the sub collector C Kala NH 143 H.
IA number also there is an application for complete on it opposite party number 1 and 2.
1 and 2. Correct designation of
to mention the correct designation of opposite party number 1 and 2. Copy has been served on the Land and Council for the opposite party, and Mr. Any objection from the Union of India?
The change of nomenclature name.
Designation टा ठीक ही नथिला तो change करियो.
I don't have objection to that.
Objection है. There no objection. Accordingly, the prayer is allowed. The learned counsel for the petitioner has already filed the consolidated cause title, which is at flag 10, and the same is accepted. Copy has been also served for the consolidated cause title.
Copy. I have not received any copy.
Consolidated. The Union of India, have you served a consolidated cause title copy?
No, Your Lordship, it has not been served upon because NHA, my learned senior is appearing. That's why perhaps they have not served it.
The land counsel for the petitioner shall serve a consolidated cause title on the land counsel for the Union of India. You are appearing for whom? Opposite party number 2.
1, Your Lordship.
2.
No, 2 pai ki appear for.
I am appearing for 2 and 4.
There is no 4 in the writ application. There is no opposite number 4 is in the writ.
In my copy, there has been handwritten one, that is PDNHI.
No, in the consolidated cause title, there are 3 opposite parties.
Two is sub-collector Kala and 3 is Tahsildar Kutra.
So you are appearing for whom, Mr.
I am appearing for sub-collector, but sub-collector is not Sundargarh. It is sub-collector Panpos.
That is there.
That is there in the consolidated cause title. It is there.
I am appearing for 2. I am appearing for 2.
Okay. All right. Mr. Ajit Patnaik, Land Council, appears
appearing for 2 and 4.
For the 4 के यहाँ दिया गया.
There is none 4.
मैंने गते जो कॉपी देइछन पिटिशन तादेर हातरे करेक्शन करी पीडीएनएचआई लिखाइछ.
टोटल तो 3 जण अपोजिट पार्टी और आगुरु भी थिला कंसोलिडेटेड कॉस्ट टाइटल भी 3 जण अपोजिट पार्टी.
I have received this copy anyway.
Mr. Counsel for the petitioner.
Yes, madam.
You have solved a copy of the writ petition in which it is mentioned that there are 4 opposite parties.
Only 3 opposite parties, my lord. I have filed earlier and consolidated cost title 3, my lord. For which I have made objection, there is no 4 opposite parties.
Opposite party number 3. The copy of the consolidated cost title shall also be served on Mr. Patnaik. So put up this matter next week कर देंगे. Date दी.
Short date, my lord.
22 तारीख आसियो. 22nd of April 2025 under the heading of admission. Yes. Mr. Mahanti, which is the matter?
This 32 million, I am in tagged matter. Mr. Bhuyan, in his case, he has tagged me. My items are, my number is writ petition 24037 of 2019 and 388 of 2020. In my case, interim orders have been already passed and the records have been called for. Record has not yet been received and the counter has not yet been filed by the state. So I pray, my lord, that interim orders to continue and this records be called for.
Your matter is item number?
Item 32, first matter. WBC number 26555 of 2019.
26555 the one.
Last time when it was listed.
Just a minute. Let us see the order. So when we took up this matter, Mr. Bhuyan, on 5/3/25, we asked you that, and you said that you will file the copy of the registered copy
of the order.
So have you complied all these orders?
I pray for some time, my lord. I have applied for the sacred copy. I have not You have to receive it.
All right, learn and
I
count.
am appearing for in Ghisi, my lord.
Just a minute, Mr. Bhuyan, learned senior advocate appearing for the petitioner submitted that as per the order dated 5/3/2025, he has applied for the certified copy of the orders in OEA case number 34, OEA claim case number 34 of 1990. And some more time will be granted to file those documents. Who is present in the opposite party?
I'm present for the Sri Jagannath Temple Managing Committee, my lord, OP number 5 in this case. I filed a counter.
Judge, opposite party number 5.
My lord.
There is there are 4 opposite parties in this.
He is open number 5.
No, it was 4 opposite party.
Sri Jagannath Temple is OP number 4.
The copy given to me, the read copy, my it is written 5. I may be 4.
He is missing.
3 is missing. That's why he got it.
Oh, 3 is
missing.
1, 2, 4,
that is
5.
what it is.
He has been described as
5. Should have been
1, 2, 4, 5. Oh, sorry.
You are on
1,
behalf
2,
of Sri
4, 5.
Jagannath Temple.
He is for
Sri
Sri
I'm
Jagannath.
sorry, man. This may be 4, my lords.
The learned counsel for the opposite party number 4, Jagannath Temple, submits that he has filed a counter affidavit. He is not for the opposite party number 5.
No, he is open number 4 because of the erroneous typing in the cost.
Yes,
So it has been mentioned in the counter affidavit that it has been filed by opposite party number 4.
It will read as 4.
Opposite party number 5. The learned counsel for the petitioner submit that he has received. You have received the copy of the counter. Copy of the counter affidavit has been received. So, we take up this matter after summer vacation. Put up this.
A copy of the counter affidavit may be served on state.
Copy of the counter affidavit is served on the land council for the state. Put up this matter. Summer vacation for the next week. This is so far as item number 132 of Pratham item. And now you come to the second item, that is 24037 of 2019. It's Vicky Ashanti. Mr. Mahanti, it is your matter.
Yes. In IA number 2849, interim order was granted on 9/3/20.
I think it has been passed in the main item also. WPC 24037.
Yes, 24037.
Interim order dated 9 March 22.
Yes.
Passed in IA 2849 shall continue.
WPC number so and so. Are Mr. Sanjit Mahanti, senior advocate. Since the connected matter, that is WPC number 26555 of 2019, has been adjourned to such and such date on the prayer of the learning council for the petitioner in this case, list this matter on that day. The interim order dated such and such, that is 9th March 2022, passed in IA number 2849 of 2022, shall continue till next date. After Aratachi, WPC number 388 of 2020.
Yes. 3125 order date. That has to continue.
Okay.
3-1.
Same type of order. For taking RRG 3/1/2020 interim order passed in IA number 31555 of 2020 shall continue
All these three cases, my lords, I am appealing for the Sri Jagannath Temple Management Committee, my lords. So in all these cases, my lords, the main order has not been challenged. Passed in the OA claim case number 34 of 1990, my lords. That is the main order which has been passed and it would form the part of the order of this miscellaneous case.
We'll hear this matter on merit when the first case is complete and you remind us on the next date so that we can, he had applied for some certified copy. We have passed the detailed order in those, the first case. Okay, so we'll hear on that day.
No, records have been called for, that has not yet.
Which records?
Kindly see WPC number 388. Noting is there. OEM is case number 34 of 2007. Arising out of
3320.
Yes.
Order dated 3320.
Order dated 3320.
Yes.
That has been called for.
Have you got that records with you, madam?
I'll bring it.
See, like your last matter, like you. It appears that the record of OEM is case number 34 of 2017, which arises out of OEA claim case number 34 of 1990 was called for. Let the Land and Council for the state keep this record ready for the next date.
Yeah.
Item 33, Malad.
Yes.
Item 33, the interim orders will continue.
These matters, rest of the matter will come tomorrow.
Malad, I'm just praying, Malad. We have informed the learned.
Malad, I am appearing for
Satya Kashyap, Malad. Malad, I'm filing my objections today. I will give copies to them, Malad. The miscases are there, Malad. I also want to file an amendment. By Monday, I will file that amendment. A date may be fixed for hearing the entire matter.
What objection you will file?
My lords, they have filed an interim application for vacating the status quo order.
Which one? IN number?
IN number 4024 of 25.
Just 4024. You want to file objection to?
I've already, objections are ready. We will serve them copies today.
Okay.
And my lords, we also want to file an amendment, a formal amendment.
To the writ petition.
To the writ application. It may come up any date for orders next week. I will give them copies. Let them file any objections.
All right. WPC number 26789 of 2020. IN 4024 of 2025. This is an application for vacation of the interim order dated 13/2/2023. Mr. Milan Kangur and senior advocate appearing for the petitioner submits that he will file objection to the interim application during course of the day, and he will serve a copy on Mr. S.K.Sahoo Hon'Ble, senior panel counsel.
Panel counsel of Paradip Port.
Of Paradip Port. Mr. Kanungo further states that he will file an interim application for amendment of the writ petition during course of this week.
By Monday.
By Monday, 21st of April 2025. Put of this matter in the week commencing from 5th of May 2025. If any interim application for amendment is filed in the meantime, the same shall be kept on record. Copy of the interim application for amendment we serve on the Land and Council for the opposite parties, right?
Oblige. Interim order may continue.
Interim order dated so and so continue till next date.
Oblige.
बाकी जो detail होगा ना शादी के
Item 23, I look listed for hearing. Unfortunately, my file is missing.
See that.
I am praying for a cell phone.
We'll go serially. These are all old matters. We'll see that.
Oh, paper book te dekhe.
Please wait. Yes, call the man.
Weekly list, item number 1.
Admission होगी
judgment
होगा
judgment which will be sir
and
jail criminal appeal to file
2007 रहेगी मतलब ही
so that's ଆମର ଇଏ proceeding ବସିଛନ୍ତି କହିଲେ କହିଲି ତମେ ବି ଯେତିକି ପୁରୁଣା matter ସବୁ ତକ ବାହାର କର ଇଏ ହୁଏ who is to look this appellant was found guilty under section 302 and sentenced to life imprisonment. So he has filed a jail criminal appeal, but he is from that point of time he was in Gunaigarh special subject. So what is the status of appellant? Or he has filed any because this jail criminal appeal has not been admitted. Can you ask to appear just now? Jail superintendent. Special subjail Bonaigarh. Ask him send message so that he will appear. We are taking up other matters, but send the message so that let him appear. And tell him that if any man is there in the name of Trilochan Kisan, Allah, he will also appear. Right? Okay. We are passing it over. Letter issued to superintendent whereabouts of the appellant on it out of letter issued to engagement of the council, condonation of the letter issued to kind of letter gang. Letter gang. Item number 1 to lekha hai. Letter issued to special superintendent special subject whereabouts found. What is that letter? So the director to inform that the appeal petition of the convict is not accompanied by the vocal of now. And we found that the request to petition will be announced and vocal of now came convict to the pro reference. This letter was issued in 2007.
No, but again, this is 22. It is 22 that they have. So, the 22. Where will this reply? Melville. In the reply, Anandu.
Have you sent message?
No, I have sent.
Do it immediately. Huh? Yes, next.
Item 2.
Sir, on the last occasion, your lordship had asked state to furnish behavior and character of the appellant when he was an interest. That report was not.
This is ours.
You have been released on interim bail.
Your lordship had granted me interim bail, my lords, earlier on 6/11/2020.
Once you have been granted.
Yes.
6/11/24. No, but there it is mentioned that you were on granted interim bail for 1 month, then surrendered.
Yes. Initially for 1 month,
Yes,
then for 2 months.
initially for 1 month, and then
for
after
2
it
months.
was
Right.
granted
Then you surrendered another 2 months have been granted and
2 months were granted on 6/11/20.
right. Then
first interim bail was granted on 29/7/2022.
okay. So
custodial detention period is now 16 years and 10 months.
So he was in custody for how many years?
16 years and 10 months. June 20th, 2007, I was taken.
That we have also mentioned here in the order dated 29/7/24. When we granted him bail for 1 month, we said that
Custody for more than 17 years.
17 custody certificate has also been annexed. Also is remained that he has remained for 16 years, 4 months, 19 days. Say, Mr. Hi. 16 ବର୍ଷ ଉପରେ ରହିଲାଣି ତ ଦିଥର ବେଲ୍ ଯାଇଛି ଆପଣଙ୍କ ରିପୋର୍ଟ ଆସୁଛି ଯେ କିଛି ଆଡଭର୍ସ ଆକ୍ଟିଭିଟି ନାହିଁ ଏଟା 2015ର ପେପର ବୁକ୍ ଅବଶ୍ୟ ରେଡି ହେଲା
Hearing.
Mr. Devashish Panda, Land Council for the petition. As per the order dated 6/11/2024 and 5/4/2025. The Land Council for the state has produced the written instruction dated 10/4/2025 received from IIC Sahidnagar Police Station, which indicates that on verification of the available PS records, no adverse activity was found against the petitioner during his interim bail period, which leads to misutilization of the property. The Vasis Funda Land Council for the petitioner submitted that the petitioner is in judicial custody for about 17 years and he was granted interim bail twice by order dated 29/7/2024 and 6/11/2024 for a period of 1 month and 2 months respectively. And even though paper book has been prepared, since there is no chance of hearing the bail application may be favorably considered. Land Council for the state proposed the pair for the considering the submission made by the Land Council for the parties. Period of detention of the petitioner in judicial custody. Fact that petitioner has not misutilized the liberty during the period of interim bail granted twice. We are inclined to release in interim bail for a period of 3 months. From the date of release, same order for the surrender certificate of conduct and basis. Yes.
Refer Arjun.
Here.
Item 3.
Item number 8 was called for as conduct report during the interim bail. Just what a telephonic instruction that he has just sending his conduct was supposed to happen. I'm yet to get the instruction in written.
Release contain
So, 48 are 25 decision 25. What about the next one? 569.
this mobile application.
First tar kichi bail application hai. Second tar achi but no is there. What is the this interim bail application he has filed? For what purpose? IA number 1112 of 25.
Ailing father. Then bring some cancer. His ailing father.
Pavitra Munda.
Paragraph 4 it says the father of the present appellant, appellant number 2, suffering from various ailments.
Pavitra Munda,
yes.
Appellant, he is the sole appellant in the criminal appeal.
There are 2 appellants.
Criminal appeal 569 is sole appellant.
Yes.
Pavitra Munda ही आज जो interim bail का
569 is only.
So he has filed an interim application for interim bail on the ground of his father's settlement. So you have received the copy of the interim application.
I have not received accessing to the liquid.
Where is the council? He has written that both the legs have been paralyzed and he is unable to answer his revision.
Medical document.
So medical document is not there. But you take instruction on that. Government's taken in particular. Achieve.
I was on file on 11th.
Hospital.
No, 6 seconds. The second matter that CRLA number 569 of 2020, IA number 1112 of 25. There is an application for bail on the ground of ailment of the father of the petitioner. None appears for the petitioner. The land council for the state has received the copy of the interim application and submits that he may be granted some time to obtain instruction on the amendments taken in the interim application. Put of this matter in the commencing on 5th May 2025. Instruction be obtained in the meantime.
Item 4.
There are also instructions with some for order dated 18th. Custody certificate. And
Submit instruction with at the status of the child of the appellant as well as the custody certificate. I'm yet to get the custody certificate. I'm submitting the copy of the status.
Date of offense is?
Pardon?
Date of offense is 23/10/2020.
2020. So as such, 4 years.
I was arrested on 20th of March 2021. Okay.
Daughter of the appellant is staying with the sister of the appellant.
Get that by next week now. The land council for the state has produced the report received from the additional IAC Southern Police Station.
Item 5.
My lord, item 5. I have not received the paperwork.
Admission ପାଇଁ ଅଛି ପରା?
ଏ ଲୋକଟାକୁ ବର୍ତ୍ତମାନ କୁହନ୍ତୁ ସେ ଆସିବ କୋଉ ଜେଲରୁ ଆସିଛି?
District jail Koraput.
ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ୍ କୋରାପୁଟ। ତାକୁ କୁହନ୍ତୁ ଜଏନ୍ କରିବ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ୍ କୋରାପୁଟ। ସେ ଲୋକଟାକୁ ନେଇକିନା ଆସିବେ ଶୁକ୍ରା ଖୋରା ହେଲା। ଡବଲ ଅପିଲ ଫାଇଲ କରିଦଉଛନ୍ତି ମାନେ ରେଗୁଲାର ଅପିଲ ଫାଇଲ Very good. GL information field. Yes, next one.
Item 6.
Sir, in this case also, I have not received the paper of my account.
Madam, these are all for fair admission
Admission,
in पर्यंत
Paper book
प्रकार बहुत दूर अब ये सर अच्छी ये जेल को जेल अच्छी
सर्कल जेल कटक
हाँ 14 को कौन दूसरे लोग को आनी प्रोड्यूस करेगा वर्चुअल मोड रे हाँ रविंद्र कुमार कर ଏଗୁଡ଼ା ସବୁ ଆମେ ପାସ୍ ଓଭର କରୁଛୁ ହଁ Yes. ତ ମୁହୂର୍ତ୍ତରେ ଯିଏ ହାଜର ହେଲା ତାକୁ ଇଏ ହେଇଗଲା ତାକୁ କହିବେ Yes, next.
Item 7.
Was directed by appearing person. He did not exactly respect the order of the court. The bell cancel here. Jury and
The bellman instruction has been received. Guru Naik arrested and produced on 15 North 8 and Juriya Naik arrested and produced on 12 Sati. Deman ବର୍ତ୍ତମାନ custody ରେ ଅଛନ୍ତି ମାଇନର ତାପରେ ଆଉ ସେ bail ଦେଇନାହାନ୍ତି so this is the latest order passed in 24.
Yes, 6 to 20.
Case ରେ paper book ହେଇଛି where is Mr. Parija? विकास परियाଙ୍କୁ ये खबर दियंतु फोन करिକି नी डकांत ए नंबर ଅଛି ନା लगा तो बाहर जाएंगे
Item 8.
Yes, yeah, person is asked.
जेल क्रिमिनल अपील तो आपण बेल जाइना शारट रे सीआर लेटर
Somebody just like to pay. Just do it with the law.
persons proper person fish plan mental handy you can also the case 3 ଜଣଙ୍କ ନାଁରେ
Samaru Jal,
Rupacharan Sahu and Kartika Dharu.
अच्छा ये तीन जनों यदि कन्विक्शन हला 302 रे लाइफ इम्प्रिजनमेंट वर्तमान सीआरएल फाइल करछन्ति दी जन ध्रुवचरण साहू एंड पद्मलोचन धारुआ.
Yes, I am for Padmalochan.
अच्छा एंड छह जन तीन जन एक्यूटर है.
Initially, FIR was filed ignited 3.
Wait.
तीन जन फाइल कर.
Accused 1, 2, 3 acquitted. Right. मतलब failed to do teacher. ये तीन जनों को ये लगा. तीन जनों जाने मतलब JCR ले और दी जनों के लिए CR ले. वर्तमान JCR ले बेल ही निकाल.
समझ जेल बेल ही.
No, madam, I am for
Das we do it no.
हाँ.
It is
All are in bail.
All are in bail.
हमर चलो JCR ले फाइल ले भाई.
अच्छा 10 9
JCR ले फाइल. JCR ले रेकॉर्ड बारो.
Lead Samaru Jar. He released on bail by an additional assistant jail.
Very तापरे आरटा जो CRL 63.
He released on bail say 10/2000.
Then out rela CRL 203 आज
on 10 to 2009.
Say good date.
3/3/2000.
3/3/2000.
That is also period.
Yeah, 10/2009 could not be completed.
Really? So the three have been directed to be released on bail. There are three one is jail criminal appeal, two are criminal appeals, right?
Yes.
So you are appearing in JCRL.
Yes.
Upon Kutre?
Padmalochan. I am
CRL
283.
283.
What about the Rupacharan Sahu? Rupacharan Sahu Amai Kiri upon how to engage for the study of the. So you have got the paperwork. Yes. So place कौन तो मैडम place कौन मैटर और टोटली कितने जन ट्रायल फेस करते ले
6
1 2 3 4 5 6 ठीक है कार्तिक को एक्यूटर होला मॉक्सफोर्ड भी एक्यूटर होला मकर तो जो कार्तिक गणेश्वर FIR person कौन
मोर नाम चूड़ामणि टिके देखाउनी टिके मोर नाम चूड़ामणि साहू
ये कितने नंबर से थी
सर FIR information number 6 मैडम PW6 में
it was 6 चूड़ामणि PW6 में अच्छा कौन तो
मोर नाम चूड़ामणि साहू थाना लोईसिंगा जिला बलांगीर
ମୁଁ ଆଜି 11/11/96 ସୋମବାର ଦିନ ସକାଳ 8 ଘଣ୍ଟା ବେଳେ ଲୁଇସିଂହ ଥାନାରେ ପ୍ରାଣରୁ ପୁଞ୍ଜ ହୋଇ ଆମ ଗ୍ରାମର ପୁଞ୍ଜ ହୋଇ ପିତା ଯୁଗେଶ୍ୱର ହୋଇ ବନବାସ ଧାରୁଆ ପିତା ଜୟକୃଷ୍ଣ ଧାରୁଆ ସହିତ ଆସି ଲିଖିତ ରିପୋର୍ଟ ଦେବାରେ ଏଇକି ଯେ ଆଜି ସକାଳ ପ୍ରାୟ 7 ଘଣ୍ଟା ସମୟରେ ମୁଁ ଓ ମୋର ଦାଦା ହରିଶ୍ଚନ୍ଦ୍ର ସାହୁ ବାରଣ୍ଡାରେ ବସି କଥାବାର୍ତ୍ତା ହେଉଥିଲା ବେଳେ
ଦାଦା
ହରିଶ୍ଚନ୍ଦ୍ର ସାହୁ
ହରିଶ୍ଚନ୍ଦ୍ର ସାହୁ
yes ma'am
ହରିଶ୍ଚନ୍ଦ୍ର ସାହୁ ଅଛି ଏକ୍ଜାମ ନେଇଛନ୍ତି
ହରିଶ୍ଚନ୍ଦ୍ର ସାହୁ
ଆଚ୍ଛା ଛାଡ଼ନ୍ତୁ ହଁ
ବାରଣ୍ଡାରେ ବସି କଥାବାର୍ତ୍ତା ହେଉଥିଲା ବେଳେ ଆମ ଗ୍ରାମର କେଶବ ହୋଇ ଆମ ପାଖକୁ ଯାଇ କହିଲା ଯେ ତମର କେତେ କିଏ ଗୋଟେ କାନ୍ଦି କାନ୍ଦି ଆସୁଛି। ଏହା ଶୁଣି ମୁଁ କେଶବ ହୋଇ ଓ କୁଞ୍ଜ ହୋଇ ମିଶି କେତେ କଣ ହଉଛି ଜାଣିବା ଲାଗି yes ma'am
ଆମ ପାଖ ଯାଇ କହିଲା କି ତମର
କହିଲା କି ତମର କ୍ଷେତରେ କିଏ
କେତେ ମାନେ ଫିଲ୍ଡ କି ଗୋଟେ କାନ୍ଦି କାନ୍ଦି ଆସୁଛି ଏହା ଶୁଣି ମୁଁ
କେଶବ ହୋଇ ଓ କୁଞ୍ଜ ହୋଇ ମିଶି କ୍ଷେତରେ କଣ ହେଉଛି ଜାଣିବା ଲାଗି କ୍ଷେତକୁ ଆସିଲୁ।
PW1 and PW କୁଞ୍ଜ ହେଲା PW4
yes ma'am କ୍ଷେତକୁ ଆସିଲୁ। ଆମେ କ୍ଷେତରେ ମୋର ଖଳାକୁ ଆସି ଦେଖିଲୁ ଯେ ମୋର ପୁତୁରା ସ୍ୱପ୍ନେଶ୍ୱର ସାହୁ ତୋରୱାଲ ଓ ବର୍ଷାରେ ବେକେ ମୁଣ୍ଡେ ଗୋଟେ କଣା ହୋଇ ରକ୍ତସ୍ରାବ ହେଉଛି।
ସ୍ୱପ୍ନେଶ୍ୱର ସାହୁ
yes deceased
ସ୍ୱପ୍ନେଶ୍ୱର ସାହୁ is the deceased ହଉ ଠିକ ଅଛି
କଣା ହୋଇ ରକ୍ତସ୍ରାବ ହୋଇ ମୋର ଖଳାରେ ପଶ୍ଚିମ ପାଖେ ମରି ପଡିଛି। ତୋରୱାଲ ଓ ବର୍ଷା ତାର
ଦେହେ ଲାଗି
ରହିଛି। ମୋର ବୁଦ୍ଧି ନାତି ବୁଦ୍ଧିମନ୍ତ ସାହୁ
PW5
yes ma'am ଟିକେ ଦୂରରେ ଜଗି ତାକୁ କଣ ହେଲା ପଚାରିବାରୁ ସେ କହିଲା ଯେ ଆଜି ସକାଳ 6ଟା ବେଳକୁ ସେ ଓ ତାର ବାପା ସବୁ ଦିନ କରି ଆଜି କ୍ଷେତକୁ ଆସୁଥିଲେ। ବାଟରେ କେନାଲ ପାଖରେ ବୁଦ୍ଧିମନ୍ତ ଝାଡା ଗଲା ଓ ତାର ବାପା କ୍ଷେତରେ ଥିବା ପୁଅ ପାଖରେ କନିଅର ଗଛକୁ ଫୁଲ ତୋଳିବାକୁ ଗଲେ। କିଛି ସମୟ କ୍ଷେତ ଆଡୁ ତାର ବାପା ବୁଦ୍ଧିମନ୍ତ ମତ ବୋଲି ବଡ ପାଟିରେ ରଡି ଛାଡିବାରୁ ମୋର ନାତି ବୁଦ୍ଧିମନ୍ତ ଝାଡା ପଦାରୁ କ୍ଷେତ ଆଡେ ଦୌଡ଼ିଲା ଓ ଦେଖିଲା ଯେ ତାର ବାପା ସ୍ୱପ୍ନେଶ୍ୱର ଘଟଣାସ୍ଥଳରେ ଓ ଖଳାରେ ଦୁମଦୁମିରେ ସମାଲୁଜାର ଗୋଟିଏ ବର୍ଷାରେ ପେଟକୁ ଭୁଷିଦେଲା।
ଦେଖନ୍ତୁ ଘଟଣାସ୍ଥଳରେ ମୋର ଖଳାରେ କଣ ଇଏ ଏଟା ଲେଖା
ଦୁମଦୁମିର
ଗୋଟେ ଜାଗା ନା ସମାରୁ ଯାଇ ମାନେ ଯୋଉ ଆପଣ JCR ରେ ଯିବା ଫଳା ଆଚ୍ଛା
ଗୋଟିଏ ବର୍ଷାରେ ପେଟରେ ଭୁଷିଦେଲା ଓ ଆମ ଗାଁର
ଗାଁର ପଦ୍ମଲୋଚନ ଧାରୁଆ ଲୁହା ତରୁଆରେ କାନ୍ଧରେ ଓ ବେକରେ ମାରିବାରୁ ଘଟଣାସ୍ଥଳରେ ସ୍ୱପ୍ନେଶ୍ୱର ସାହୁ ପଡିଗଲା। ଏହି ସମୟରେ ଧ୍ରୁବ ସାହୁ ଥର ଥର ମାରି ଦିଅ ବୋଲି କହି ପାଟି କରୁଥିଲା। ଘଟଣା ପରେ ମୁଦାଲା ସମ୍ବାଦୁଜାର ପଦ୍ମଲୋଚନ ଧାରୁଆ ଓ ଧ୍ରୁବ ସାହୁ ଘଟଣାସ୍ଥଳ ଛାଡି ଦୌଡି ପଳାଇଗଲେ। ଗଣେଶ୍ୱର ଧାରୁଆ ଓ କାର୍ତ୍ତିକ ଧାରୁଆ ଯିଏକି ଘଟଣା ଜାଗାରେ ପ୍ରାୟ 50-60 ମିଟର ଦୂରରେ ତାଙ୍କ ଆଡକୁ ଆସୁଥିଲେ ସେମାନେ ମଧ୍ୟ ଦୌଡି ପଳାଇଗଲେ। 1944 ସାଲରୁ ମୋର ବାପା ଲବଣୀ ସାହୁ ଓ ଅମଳରୁ 5 ଏକର ଜମି ବଣ୍ଟା ବାବଦକୁ ଧ୍ରୁବ ସାହୁଙ୍କ ସହିତ ଦେବାନୀ ମକଦ୍ଦମା ଏପର୍ଯ୍ୟନ୍ତ ଚାଲୁଛି। ସେହି ରାଗରେ ଧ୍ରୁବ ସାହୁ ତାର ସପଟରେ ଉପରୁକ୍ତ ଲୋକମାନଙ୍କ ସହ ମୋର ପୁତୁରା ସ୍ୱପ୍ନେଶ୍ୱର ସାହୁଙ୍କୁ ତୋରୱାଲ ଓ ବର୍ଷାରେ ମାରି ଦେଇଛନ୍ତି।
So as it appears that against 3 persons there are allegations and that is how
Direct
the
assault.
case was registered against 3 persons, and those 3 persons have been found guilty, and the rest 3 have been acquitted.
Yes, sir.
So obviously se PW5 hochi are eyewitness now ki achanti
Only PW5 is the
only eyewitness. Just who is the doctor who conducted PM?
Dr. PW8. PW8, sir.
अच्छा PW5 को जीवा पूर्व आगे PW8 को पड़े PW8 का पेज कहते हैं
48.
48
Page 148.
148.
oh 148
Page 148.
wait 148 awesome hold on
PW8 on 11/11/1996. I was assistant surgeon district headquarters hospital, Bolangir. On that day at 4:15 p.m. on police requisition, I conducted postmortem examination over the dead body of Sapneshwara Sahu, son of Harish Chandra Sahu, of village Sujia P.S. Loishinga, and found as follows: external injury, 1, 2, and through penetrating
Penetrating.
in Bacha, entered through right side of the abdomen and coming out on the right side just between fourth and fifth ribs spaces with the hip and back portion seen outside the body. Second,
नहीं पछाड़ बोले
like it पछाड़ तो बाहरी
हाँ राइट साइड माने एब्डोमेन ने पसिची coming out on the right side chest
तळु ऊपर
तळु हो जाई छै fourth and fifth ribs अच्छा
पंचर penetrating
one incised and penetrating wound of size 4 inch depth of 1 or 2 inch length and 1 foot wide, along with the bent talwar over the right side neck, half inch below the mandibular angle.
bent talwar
Had one inside wound of size 10 inch length, 1.5 inch breadth, and 2.5 depth of right side neck. One inside wound.
Number of injuries are there, all are incised wound.
Yes, ma'am.
And not injuries total से देखी and according to him, injury number 1 pierced the abdominal well, liver and lower part of the right lung, right posterior chest wall with fracture of fourth and fifth rib. V number ta injury to the parotid vessels, fracture of cervical fourth vertebra. Tinta hochi vessels of the neck and fracture of cervical fifth vertebra. 7 number right shoulder joint, so on so on. Injury number 1 is sufficient in ordinary course of nature to cause death. Injury number 2 is also sufficient in ordinary course of. All the injuries are antemortem. Cause of death was due to hypovolemic, so on so shock. Acha. Injuries could be possible
on the same day on
police. Barcha Tolwar there in opinion dela and say opinion positive asla. Okay. ବର୍ତ୍ତମାନ ପଳେଇ ଆସନ୍ତୁ PW5 पेज कहते हैं
115
115 page. I know the accused person standing in the dock on 11/11/96 Monday at about 6 a.m. while I, along with my father, CHITTARANJAN, were going to our land from our house. I went to attend call of nature on the way, whereas my father proceeded towards our land. While I was cleaning myself after attending call of nature, I heard Hulla of my father, who was shouting, saying, Buddhimanta, Buddhimanta, Marigali, Marigali. Thereafter, I started running towards our land from the Jadahata near a shimuli tree. I saw accused person assaulting my father by surrounding him. Accused Makaradhaja assaulted him with an axe. On his day, accused
On his head.
on his head. Sorry. Accused Samaru wears a spear on his body. Accused Padmalochan
ଦୋଷଟା ଆକ୍ୟୁଟାଲ ହେଇଯାଇଛି
ଆଜ୍ଞା
ଯେ ତା ନାଁ ନଥିଲା ଠିକ ଅଛି ତାପରେ ସମରୁ
pierced
କନଭିକ୍ସନ ହେଇଛି
Yes.
pierced his spear on his body.
ତାପରେ
Padmalochan assaulted him with a sword. Accused Purva assaulted him with a gujari. Accused Ganeshwara and Kartika assaulted with lathis to my father.
ଗଣେଶ୍ୱର ଆଉ କାର୍ତ୍ତିକ ଆକ୍ୟୁଟାଲ ହେଇଛନ୍ତି ନାଇଁ
Acquittal agent. When I raised Hula on seeing the assault of my father, the accused persons chased to assault me. Out of fear, I came running to our village. On the way to my village near the canal, I met Chudamani Sahu, the uncle of my father, Punja Bhoi and Kesava Bhoi of my village, and told them the occurrence. I told them that accused Makaradhaja with 5 others killed my father, and when
I raised Hulla, they
chased me to assault, and
as such I was going away.
I am going away by running to the village. Thereafter, I, along with them, went to the spot and found my father lying dead there. There was profuse bleeding from his body. We saw a sword sticking to the neck of my father and a spear first and penetrated below the right side armpit and had come out at the left side armpit of my father. We found multiple bleeding injuries on the body of my father. At that place, when Chudamani Sahu again asked me the occurrence, and I narrated the occurrence before him. At that time, Punja Bhoi disclosed before us that the accused person had
held a meeting
in the previous night in the house of accused
PW4.
Yes, ma'am. In the house of Makaradhaja to kill my father, and out of fear, he could not confirm that fact to us in that night. The accused were not feeling unwell with my father by the time of the occurrence. There were several cases between my father and accused Makaradhaja. About 2 months prior to the occurrence, the wife of accused Makaradhaja died. On the death of his wife, accused Makaradhaja gave
about that. My father killed his wife by doing witchcraft.
I had come to know that incident from Punjab about 3 to 4 days prior to the occurrence. I cannot identify the spear.
I can
identify the spear and the sword with which my father was assaulted. This is the spear MO4 and this is the sword marked as MO5. On 11/11/96, at about 10 a.m., police seized the 3 pair of chappals, 3 empty liquor bottles, smelling liquor, 1 armpit of my father, and MO4 and 5 beside a pair of chappals of my father. At the spot, Punja Bhoi, Kishore Sahu, and Ravi Chandra Pradhan were present with me at the time of seizure. This is the seizure list, Exhibit 2, prepared by the police in our presence. There, this is my signature by on 23/3/19, I had given my statement before the JMFC Loishinga. This is my statement before mark exhibit 6 with objection and my signature exhibit 6 by 1 and exhibit 6 by 2. Chudamani Sahu lost the report about the occurrence in Loishinga PS on 11/11/96. I was examined by the police on criminal crime branch on 4/10/97. Out of the 3 pair of chappal marked as M02, the chappal having blue type tapes belonging to my father, the plastic chappal belonging to the accused Rupa Sahu, and the 3rd pair of chappal belonging to accused Samarujan, the field servant of the accused of Mukarafajam. She committed in the year 1990. I was student of class 2 first year and arts and Loishinga College. Police come to the spot at about 7:30 to 8 a.m. on 11/11/96. The police were of Loishinga PS. The outsider come then in the spot. No outsider come then to the spot.
Yes, read the cross examination.
Yes. Cross examination. खाली सोमवार उजाला पढ़ी ସମସ୍ତଙ୍କର cross examination. 6 further cross examination resume on 27/11/2002. I was examined by police of Loishinga PS in this case. It is not a fact that I have not stated before the police of Loishinga that while I was cleaning myself after attending call of lecture, I heard hula of my father, who was shouting, saying, Buddhimanta, Buddhimanta, Marigali, Marigali. And that I saw accused Ganeshwara and Kartika assaulting my father and with lathis.
No, that has been confronted and it has been proved to the IO. You come to page number 158. IO's evidence is
Yes,
IO is PW. I which PW 9. PW 9 ର paragraph 8 କୁ ପଳେଇ ଆସନ୍ତୁ. Page ହଉଛି 158.
Rule 6 had not stated.
ପାଇଲେ? Page 158. ହଁ 158. ହଁ ପଢନ୍ତୁ କଣ ସେ କହିନି ସେ ଯଦି କନଫ୍ରଣ୍ଟ କରି ଇଏ ତାକୁ 158 paragraph number 8.
PW6 had not stated before me that while he was talking with his elder brother Harishchandra Sahu, Kesava Bhai came running from the side of the tank of their village and inquired if Buddhimanta Sahu and Sapneshwara Sahu were present in their house. And he replied that they had gone to the land. He had not stated before me that Kesava Bhai told them that PW5 was crying on their land, and that he told Kesava Bhai to go with him to their land and at that time when Kunja Bhai came to them, he requested him to accompany them, and that near a canal bridge they met PW5 was accompanied by crying from the side of their land. At that PW5 told them that 5% along with accused Makaradhwaja killed his father and that they found a toothbrush, one tongue cleaner and some flowers at tulsi leaves lying near the deceased at the spot, and that PW5 had a hard sound of his father as Marigali, and that PW5 told him that when he lost towards the spot, he saw from near a
What a PW6 na? PW6 is the sole eyewitness.
No,
PW5.
PW5.
No. ଆପଣ ଯୋଉଟା ପ୍ରେସ୍
PW6 ଆପଣ ପ୍ରେସ୍ PW5 ଟା
PW5 ର
para 7.
ଆଚ୍ଛା PW5 ର
PW5 ଟା para
7. Then it is 157.
7 part.
ହଁ ସେଇଟା ପଢନ୍ତୁ। କାରଣ ଏଇଟା sole eyewitness। Please come to the contradiction part.
56 para 6
हाँ पढ़ो।
BW 4
अरे I know that.
नहीं
Please come to paragraph 7, page 157.
Yes. BW5 had not stated before me that he had hula of his father as Morigali, and that he saw accused Ganesha and Kartika assaulting his father with lathi, and that when he raised hula on seeing the
assault on his father.
assault of his father, the accused person chased to assault him, and that on the way to his village near the canal, he met Churamani-Sahoo, the uncle of his father, Kunja Bhoi and Keshava Bhoi of his village, and told them the occurrence. On that, thereafter, he along with them went to the spot and found his father lying dead there, and there was profuse bleeding from his body, and a sword and a spear sticking to his body, and also saw multiple bleeding injury on the body of this father. At that place, Suramani again asked me about the occurrence, and that Punjabhoi at that time disclosed before them that the accused person had
Held a meeting.
In the
assault made by the three persons are not confronted. That he has stated. Only with regard to the that he has stated. With regard to the assault made by the three persons.
गणेश्वर कथा कहनी टोटल 161
कार्तिक नहीं मकर ध्वज
कथा नहीं ଆଉ ଟିକେ
मकर ध्वज it is not affected मकर ध्वज
मीटिंग कथाटा
हाँ मीटिंग कथा नहीं
मकर ध्वज घरे मीटिंग होतला सेटा
नहीं ताने सेतबे तीन जन को सुपर दिस विल
Now you come to the paragraph 7. It has the confrontation चलला. Paragraph 7 को पढ़े आसो. Cross examination. The PW 5 रो. जो sole eyewitness. तार paragraph 5 7 को आसो तो page होची 118.
There is a canal in between.
There is a canal in between my village and the land locally known as Amda. That I had not attended call of nature near that canal, but I had attended the call of nature near a canal situated near our land. It is not a fact that there is no canal near our land. There is a farmhouse of desiccation and prana near our Jotota. I had attended call of nature for a minute or two. The spot is our land. There is a well at a distance of about 50 to 60 cubit from the spot. The canal near which I attended call of nature situated to the west of our land. The canal runs from north to south. That is the only canal of our village. The land of distribution adjoins that canal where I had gone to attend the call of nature. I went to the Jodota, the land of Rishikesh. There is a pathway adjoining the Jodota. That pathway leads to the spot and also leads to the Loishinga. We had grown a Jodota crop on that Jodota in the year of occurrence. The Shimuri tree from which I saw the occurrence stand on the western side of the Jodota. Some other trees were also there in Jodota on the beach. I had not gone to the farmhouse of Dishikesonarana while proceeding to the spot. None resides in the farmhouse. I had not entered inside that farmhouse and as such, I cannot say if anybody anywhere where there at that time. I had seen accused Makaradhaja assaulting on the right side of the head of my father with an axe. There was no bleeding from the body of my father. Before accused Makaradhaja assaulted with with an axe, my father did not fall down. After accused Makaradhaja assaulted him with the axe, after Makaradhaja and Makaradhaja accused Samaru assaulted my father with a spear, and then my father fell down on his left side. Accused Padmalochana did a sword below the neck of my father. Accused Rupa assaulted on the right arm of my father with a bujat from its sharp side. I heard the sound of my father till he was assaulted by accused Rupa with a bujali. Ganeshwara and Kartika assaulted on the back of my father with lathi. All the accused person chased me when I raised Gula. I went running through the land of Vishikeshwarana and Am Adar Dadar towards our village. When the accused person chased me to assault on the way to my village beyond Dadar, I met Chudamani Sahu, Kunjapoi and Keshavapoi near the canal village. I had not seen my backside while running towards our village. I could not know. I could know the accused person taking me to assault to the farmhouse of Vishikeshwarana. I had not seen the accused person when I met Chudamani, Sahu, Kunjapoi and Keshavapoi. Accused Makrodhaja was armed with an axe, and accused Ganeshwara and Kartika were armed with lathis. While chasing me at about 6:30 am of that day, I, along with Chudamani Sahu, Kunjapoi and Keshavapoi, reached at the spot. The accused persons were not present at or near the spot when we reached there. No outsider was present near the spot where we four reached there. After 10 to 15 minutes of our arrival at the spot, Churamani Sahu went to Jaishinga PS to report the occurrence which I had narrated to him. Churamani Sahu went to that PS by foot, and none had accompanied with him to the PS from the spot. Churamani Sahu reached at the spot from the PS after arrival of the police. After Chudamani reached at the spot, I inquired from him and came to know that he had reported the occurrence in the PS. Police asked me the occurrence while holding inquest over the dead body of the deceased, but did not record my statement there. After seeing the dead body of the deceased at the spot, police went to our village and then again came to the spot. Thereafter, police have held inquest over the dead body of the deceased and made the decision. Kunjabhoi, Keshavabhoi, Ravi Chandra Pradhan, and many other persons were present at the spot beside me when police held the inquest. Kunjabhoi, Keshavabhoi, Ravi Chandra Pradhan, Kishore Sahu, and Chudamani Sahu had put the signature in the inquest slip. Police sent the dead body of the deceased from the spot at about 5:30 p.m.
Just him. You see the PW6, who is the informant. He is not an eyewitness to the occurrence. Post occurrence. ତାକୁ information ଦେଲା କିଏ? PW5 ଦେଲା। ତେଣୁ prosecution case ହଉଛି PW5 ହଉଛି eyewitness। ସେ ଘଟଣା ଦେଖିଲା, ଦେଖିକିନି ଆସି PW6 କୁ ଜଣେଇଲା। ତାପରେ PW6 ଯାଇକି ଏତଲା ଦେଲା। ତ ଏତଲାରେ ଟୋଟାଲି ସେ ଇମ୍ପ୍ଲିକେଟ କରୁଛି 3 ଜଣ accused ତା ବାପାକୁ ମାରିଲେ ବୋଲି। ଯୋଉ 3 ଜଣଙ୍କୁ କନଭିକ୍ସନ ମଧ୍ୟ ହେଇଛି। ଏବଂ ମାରିଲେ 2 ଜଣ ମାରିଲେ, ଜଣେ ତାଙ୍କୁ ଆବେଟମେଣ୍ଟ ହେଲା। ତ ତେଣୁ ସେତିକି ଇନଫର୍ମେସନ ପାଇଯିବ PW6 କୁ। PW6 କୋର୍ଟରେ ଆସିକିନି କହୁଛି ଯେ ନାଇଁ ସେ 3 ଜଣଙ୍କ ଛଡା ଆଉ 3 ଜଣ ମଧ୍ୟ ମାରିଛନ୍ତି। So obviously that fact cannot be believed and that was rightly discarded by the trial court and those persons have been acquitted. And there first hand information thila before PW5 ଯେ 3 ଜଣ ହିଁ ମାରିଛନ୍ତି deceased। ଯୋଉମାନଙ୍କର ନା FIR ରେ ଅଛି ଏବଂ FIR ରେଜିଷ୍ଟର୍ଡ କେବଳ ସେଇ 3 ଜଣଙ୍କ ନାଁରେ ହେଇଛି। 2 ଜଣ ମାରିଛନ୍ତି, ଜଣେ ଇନଷ୍ଟିଗେଟ୍ କରେ। ଆଚ୍ଛା, ଯଦି ଏଇ ଯୋଉ 3 ଜଣଙ୍କୁ ଆମେ ଦେଖିବା, 2 ଜଣଙ୍କ ନାଁରେ ଯୋଉ ଓଭରଟ୍ୟାକ୍ଟ ଅଛି assault, ସେଇଟା ମଧ୍ୟ ତାର PW6 ର ଏଭିଡେନ୍ସ ରେ ଅଛି। କିନ୍ତୁ ଯୋଉ ଆବେଟମେଣ୍ଟ ହଉଛି ଧ୍ରୁବ ନାଁରେ ସେତେବେଳେ ଥିଲା ଆବେଟମେଣ୍ଟ, କିନ୍ତୁ ବର୍ତ୍ତମାନ କୋର୍ଟ ରେ କହୁଛି ନାଇଁ ଧ୍ରୁବ ବି ମାରିଥିଲା,
ବୁଝିଆଲିରେ ମାରିଲା।
ବୁଝିଆଲିରେ ମାର। ତେଣୁ ସେଇଟା ଗୋଟେ ଡେଭଲପଡ, ଅର୍ଥାତ ଏଇ ୱିଟନେସ ର ସେଇ ପାର୍ଟ ଟା ଗୋଟେ ମାନେ ଡାଉଟ କ୍ରିଏଟ ହଉଛି। ତେଣୁ ଅନ୍ୟ 2 ଜଣ ପାଇଁ ଠିକ ଅଛି, ମାନେ ଏଇ ଯୋଉ ସମୃଜାଲ ଆଉ ପଦ୍ମଲୋଚନ। But so far as Dhruva is concerned, so the initial story of the prosecution is that he abated the crime, which was disclosed by PW5 to PW6, right? But in the trial stage, or it is stated that this Dhruva also assaulted. So that was not the initial story. So that is very difficult to be accepted. So ଏଇ 2 ଜଣଙ୍କ ପାଇଁ ହେଇପାରିବ ଏଇ ଲୋକଟାକୁ doubtful their participation. So even if this witness cannot be said to be fully reliable because of improvement. But so far as the 3 categories of witnesses in criminal trial, it is stated that if it is a wholly unreliable, you have to discard the evidence. If it is wholly reliable, then you have to accept even no corroboration is required. But if it is partly reliable and partly unreliable, then you have to seek for material corroboration. ତେଣୁ material corroboration in the form of medical evidence ଆସିଯାଉଛି। ସେ ଯୋଉ କହୁଛି ତାକୁ ପୁରେଇ ଦେଲା ସେଟା medical evidence ରେ ଆସୁଛି ଯେ ସେଟା ବର୍ଚ୍ଛା ତା ଭିତରେ ରହିଛି, ସବୁ ପିୟର୍ସ କରି ରହିଛି, corresponding injury ରହୁଛି। ତେଣୁ ଏଇ ସବୁ ବିଷୟ ଦେଖିବାକୁ ଗଲେ ସେ 2 ଜଣଙ୍କ ପାଇଁ ଏଭିଡେନ୍ସ ରହୁଛି, whereas ଧ୍ରୁବ ପାଇଁ ଟିକେ doubt ଯେହେତୁ ରହୁଛି, in that way he can be given benefit of doubt because his role is as per the prosecution case is inconsistent. One stage, at the initial stage, you are saying that he has just abated. In the subsequent stage, you are saying that he is also assaulting by discharge. What do you say, madam? Anything you further want to say?
Madam, is that Now his age is near about 70.
Karo.
Amaruja.
No, once we find that they have already been released on bail. So once we find that the manner in which they have assaulted, you see 9 injuries have been caused.
Yes,
and
sir.
all those injuries are either penetrating wounds or incised wounds. And
the very vital part of
so
all
far as this that name, what is his name?
Samaruja.
Samaruja नारे कौन बोची?
He pierced the
Samaruja pierce करला
Barcha.
ବର୍ଚ୍ଛା ସେ ବର୍ଚ୍ଛା ମଧ୍ୟ ତା ଭିତରେ ଥିଲା
ଲାଗିକି ରହିଥିଲା।
ଲାଗିକିନି ରହିଥିଲା ଏବଂ
ଆରପଟେ ବାହାରିଛି।
that is the that has caused
Fatal,
injury
yes.
number 1. And injury number 1 according to the doctor is the fatal injury, and that is sufficient in ordinary force of nature to cause death.
Singly.
है ना एकुटिया गोटे इंजुरी भी ଦେଇଥିଲେ ତେଣୁ ଏଠି ଆଉ ଗୋଟେ ଅନ୍ୟ ସେକ୍ସନ କୁ କନଭର୍ଟ କରିବାର ସ୍କୋପ ହିଁ ନାହିଁ ଯୋଉ ଟାଇପ ର ଇଞ୍ଜୁରି କରିଛନ୍ତି ଯୋଉ ଟାଇପ ର ମେଡିକାଲ ଏଭିଡେନ୍ସ ଆସିଛନ୍ତି ସୋ ଏଠି ଆଉ କିଛି ଆସୁନି
କୋର୍ଟ ନେକ୍ ରେ ଯାଇଛି ନେକ୍ ଭେସଲ୍ସ କଟିଛି ଡାଇରେକ୍ଟଲି ନେକ୍ ବେଣ୍ଡ ହେଇଯାଇଛି the sword was found to be bent.
The appellants Samrujal in GCRL number 54 of 2005 appellant Dhruvacharan Sahu in CRL number 63 of 2005 and appellant Padmolochan Dharua in CRL number 283 of 2006 along with accused persons Kartiko Dharua, Mokardosh Dharua and Ganeshwar Dharua faced trial in the court of Learned Additional Session Judge FTC Balangir in Sessions case number 120 for offences punishable under section 302 by 34 IPC 120B by 34 IPC on the accusation that on 11/11/1996 at about 6 a.m. at village Sujia under Luisinga police station in the district of Balangir, they committed murder of S.K.Sahoo Hon'Ble, bracketry hereafter deceased, and in furtherance of their common intention. And they had also criminal conspiracy to commit such crime. The London Trial Court had judgment and order dated 20/1/2005, though acquitted who accused persons, namely Kartiko Dharua, Mokardosh Dharua, and Ganeshwar Dharua, of all the charges and the appellants of the charge under section 120B by 34 of the Indian Penal Code, but found the appellants guilty under section 302 by 34 of the Indian Penal Code and sentenced them to undergo RI for life. Stop. The prosecution case, as per the first information report presented by Chudamani Sahu, bracket PW6, on 11/11/1996 before the officer in charge of Loishinga police station, in short is that on that day at about 7 a.m. while he along with his paternal uncle Harish Chandra Sahu was sitting in the on the veranda and gossiping, at that point of time PW1 Kesavo Bhoi informed him that someone is crying in their field. Stop. Hearing it, PW6, the informant, along with PW1 and PW4, proceeded to the field and found the deceased was lying dead with bleeding injuries and sword and barcha had been pierced in his body. And PW5 Buddhivanta Sahu, was the grandson of the informant, bracket PW6, was present there, and he disclosed that at about 6 a.m. on that day, while he, along with the deceased father, were coming to the field, on the way near the canal, PW5 went to attend call of nature. The deceased went to collect some flowers. After some time, PW5 heard shout of the deceased and immediately rushed towards the place from where such shout was coming, and he found that the deceased was being assaulted by appellant Samarujal with a barcha, which he pierced in the abdomen of the deceased, and the appellant Padmolochan Dharua assaulted the deceased by means of a sword on the shoulder as well as on the neck, for which the deceased died. The accused persons, the appellant Dhruva was also present at the spot, and he was awaiting the other two appellants stop. After committing the crime, the appellants left the spot stop. It is further stated in the first information report that since 1944, there was civil dispute between the deceased and appellant Dhruva Sahu, and cases have been instituted, and for such civil dispute, the appellant Dhruva, along with the appellants Samaru Jal and Padmolochan, committed the crime. On the basis of such first information report, Loisinga PS case number 95 of 1996 was registered under section 302 by 34 of the Indian Penal Code against the three appellants. By PW9, the OIC of Loisinga Police Station, who himself took over the investigation of the case. During course of investigation, he examined the witnesses, visited the spot, prepared the spot map exhibit 11, seized some material objects from the spot as per seizure list exhibit 2, held inquest over the dead body of the deceased and prepared inquest report exhibit 1, sent the dead body to the district headquarters hospital Balangir for post-mortem examination, seized sample earth and blotched earth from the spot as per seizure list exhibit 3, and also on 12/11/1996, he seized the command certificate, the wearing apparel of the deceased, so also the weapons which were found struck in the body of the deceased on being produced by the escorting constables under seizure list exhibit 7. On 13/11/1996, the appellants Dhruvacharan Sahu and Samaru Jal were arrested and forwarded to court. he received the post-mortem report and also received the opinion relating to the possibility of the injuries sustained by the deceased by the weapons seized, sent the exhibits to RFSL Ointapalli Sambalpur through JMFC Loisinga for chemical examination and also received the chemical examiner's report. And on completion of investigation, he submitted charge sheet against the 3 appellants, namely Samaru Jar, Dhruvacharan Sahu, Padmalochan Sahu, showing Padmalochan Dharua as absconder. ये वो परे क्वेश्चन ये देखिए चार्जशीट में भी 3टा ला रहे ना एक सीन
2006 12 2021 रे
Padmalochan has been shown as absconder.
Padmalochan आरो 3टा कोन 319 क्वेश्चन
Thereafter, my lord, the wife of the deceased, Puri Sahu, and the infant moved an application for the Honorable High Court, OJC number 56000 and seeking crime as investigation.
judgment.
Second, my lord, judgment page 4.
Judgment page 4.
So the matter was impacted by the crime branch, or these 3 persons has been added.
It appears
The crime branch police
that the case was reopened as per the pursuant to the direction of this court in OJC number 5600 of 1997, which was filed by the wife of the deceased, and accordingly the crime branch took up the investigation and submitted charge sheet against the 3 other co-accused persons, namely Makardhoj Dharwa, Kartik Dharwa, and Ganeshwar Dharwa, besides the appellants who were charge sheeted earlier. All the sessions cases were tagged together. The defense plea of the appellant was one of denial, and it is stated that due to previous party faction in the village, they have been falsely implicated. Stop. The London trial court, after assessing the evidence on record, came to hold that there is no evidence to show that there was any agreement between the conspirators to commit the offense, and there is no evidence that the accused persons had proceeded to witness Kali Puja to Loisinga and thereafter kill the deceased. Mere gathering is not enough to prove an offense in absence of proof of agreement between the parties, and accordingly held that the prosecution has failed to prove a case under section 120B of the Indian Penal Code against the accused persons. The London trial court further held that the facts and circumstances of the case makes it clear that the offense has been committed by appellants Dhruvacharan Sahu, Padmalochan Dharwa and Samrujal in furtherance of their common intention. The fatal blows by the deadly weapons were given by Padmalochan Dharwa and Samrujal, and the mastermind working behind them was none else but appellant Dhruvacharan Sahu, and accordingly found them guilty under section 302 by 34 IPC. However, so far as the three co-accused persons are concerned, who were subsequently added in the case on the basis of crime branch investigation, the London Trial Court has held that the prosecution has failed to prove case under section 302 by 34 against them beyond all reasonable doubt. The you are appearing in Ms. Sinha. You are appearing in legal rights. अच्छा आपको appear करते कहाँ पाएं?
पद्मालोचन
अच्छा
283
अच्छा 283 हम गेस करते हैं T Sinha को देखो Miss T Sinha, London Council, who is appearing for the appellant Samrujal, is engaged as amicus curiae for the appellant Dhruvacharan Sahu in CRLA number 63 of 2005. You are Mr. Arvind Tripathi.
Amiya Kumar Beura.
Amiya Kumar Beura. You have no power in this case. कौन ना कौन?
Amiya Kumar Beura.
Amiya Kumar
Beura.
Behra ना?
Beura.
Beura. Miss Sinha appearing, Miss Sinha also Mr. Amiyacharan Beura, Land Council appearing for the appellant Padmacharan Dharwa in CRL number 283 of 2006, contended that the conviction of the three appellants is based on the solitary evidence of PW5, who is none else than the son of the deceased, and he cannot be said to be an absolutely reliable and truthful witness in as much as the trial court has not accepted the implication of three co-accused persons as deposed to by him in connection with the murder of the deceased. The Land Council submits that the evidence of this interested witness, which has been partly disbelieved by the London Trial Court, cannot be accepted to convict the three appellants. The Land Council further submits that even though at the initial stage there were no allegation whatsoever against the three co-accused persons, and the FIR was lodged only against the three appellants, but the prosecution developed its case at a later point of time, and a charge sheet was also submitted against the three appellants, the prosecution developed its case at a later point of time and implicated the three co-accused persons who faced the trial and got acquitted. The Land Council further submitted that the informant has no bucket PW6 has no direct knowledge about the incident, and whatever he has stated in the first information report is being disclosed to him by PW5, and in the FIR there is nothing that appellant Dhruvacharan Sahu assaulted the deceased by means of Bujali, which is deposed to by PW5 in his evidence, and the only overtact that has been attributed against the said appellant was of abatement abatement was inciting the appellants Samru Jal and Padmalochan Dharwa, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellants. Mr. Sarat Kumar Pradhan, an additional standing counsel, on the other hand, supported the impugned judgment and submitted that even though the evidence of PW5 regarding implication of the three co-accused persons have not been accepted, but his evidence relating to the overtact committed by the three appellants is getting corroboration from the medical evidence. The doctor has noticed not only penetrating wound along with the spear which has been entered in the abdomen, and a bent talwar in the right side neck, but other incised wounds, and who find that injuries number 1 and injury number 2 itself sufficient in ordinary course of nature to cause death. The Land Council further submits that even if the role played by Dhruvacharan Sahu as stated by PW5 that he assaulted by means of a Bujali can be said to be an exaggerated version because the said same is not there in the first information report, but all the same, even if he has abated the crime, is equally responsible like the appellant Samru Jal and Padmalochan Dharwa, and therefore there is no infirmity or illegality in the impugned judgment and order of conviction, and therefore all the three appeals should be dismissed. Adverting to the contention raised by the Learned Council for the respective parties, we have to first see whether the prosecution has successfully established that the deceased Sapneshwar Sahu, whether the prosecution has successfully established that the deceased Sapneshwar Sahu has made homicidal death or not. In this connection, apart from the inquest report prepared by the IO bracket PW9 as per Exhibit 1, the evidence of PW8, the Assistant Surgeon District Headquarters Hospital, Balangir, who conducted post-mortem examination for the dead body of the deceased on 11/11/1996 is very relevant. PW8 has noticed the following external injuries. He has opined so and so. He has proved the post-mortem examination report as Exhibit 9. He further stated that on police requisition, he examined the barcha and talwar and opined that the injuries found on the deceased would be possible by such weapon. And the opinion has been marked as Exhibit 10, and the barcha has been marked as MO4 and the talwar has been marked as MO5. Nothing has been elicited in the cross-examination to disbelieve the evidence of PW8. The London Council for the appellants have also not seriously challenged the evidence of PW8. Considering the submission made by the London Council for the parties, the inquest report, the evidence of the Dr. PW8, the post-mortem report, we are of the view that the finding of the London trial court that the deceased met with a homicidal death is quite justified. Now coming to the evidence of the witnesses, there is no dispute that the prosecution case regarding the culpability of the appellants hinges on the acceptability or otherwise of the evidence of the solitary eyewitness PW5. Law is well settled that in order to act upon the evidence of a solitary witness, the evidence must be clear, cogent, trustworthy, above and truthful. The PW5 has stated that on the date of occurrence, that is on 11/11/1996 at about 6 a.m., he along with the deceased were going to their land from their house, and he went to attend the call of nature on the way, and his father, bracketed deceased, proceeded towards the land. While he was cleaning himself after attending the call of nature, he heard Pulla of the deceased shouting, Budhibanto, Budhibanto, Morigoli, Morigoli, inverted comma. Then he started running to the land and found that the appellants were assaulting his father by surrounding him. He stated that the accused Mokrodhos assaulted the deceased with an axe on the head. Appellant Samru pierced a spear on the body of the deceased. Appellant Padmalochan assaulted him with sword. Appellant Dhruva assaulted the deceased with a bhujali, and the accused persons Ganeshwar and Karthik assaulted the deceased with lathis. He has further stated that when he raised halla on seeing the assault on the deceased, the accused person chased to assault him, for which, out of fear, he came running to the village where he met PW6 Chudamani Sahu, the uncle of his deceased father, Kunjavui bracket PW4 and Kesava Bhui bracket PW1, and told them about the occurrence. He further stated that he, along with others, came to the spot and found the deceased lying dead there. And there was bleeding, profuse bleeding from his body. And they saw a sword was sticking to the neck of the deceased, and a spear was pierced and penetrated below the right side of the armpit and had come out at the left side armpit. There were multiple bleeding injuries on the body of the deceased. The witness has further stated that 2 months prior to the occurrence, the wife of accused Makradhos died, and on the death of his wife, accused Makradhos had threatened to kill the deceased, as he was suspecting that by the wife died on account of practicing of witchcraft by Makradhos,
by
Sapneshwar, and that he would kill Sapneshwar, bracketed deceased body. Though lengthy cross-examination has been made to the PW5, and the previous statement has been recorded under section 161 CRPC by PW9 has been confronted, but we find that it has been proved through PW9 that PW5 that he has not stated to have heard his father, bracketed deceased, saying Marigali Marigali, and that he saw the accused persons Ganeshwar and Karthik assaulting the deceased with lathis, and that he raised Ullah on seeing the assault on the deceased, and that the accused person chased to assault him, and that on the way he met PW6 and other witnesses and told them about the occurrence, and that thereafter he, along with them, came to the spot and found his father lying dead with multiple injuries, and that appellant had held a meeting on the previous night along with the three co-accused persons in the house of Makradhos to kill his father, and out of fear he could not inform that fact to them in that night, and that he had not implicated the appellant Karthiko and Ganeshwar in the crime in his statement recorded under section 161 CRPC. The London trial court has rightly taken into account that the initial version of PW5 before the informant bracket PW6 was only with respect to the three appellants, and therefore the implication of the three co-accused persons, namely accused Makardhoj, accused Kartiko Dharwa, Mokardos Dharwa and Ganeshwar Dharwa were not accepted and they were acquitted of all the charges. So far as the appellants Samrujal and Padmalochan Dharwa is concerned, we find that not only the evidence of PW file is consistent in that respect, but also he has disclosed about their complicity in the crime, in the direct assault of the deceased before PW 6, the informant, and that is how it finds place in the first information report. So far as so far as the apparent Dhruvacharan Sahu is concerned, though in the court he has stated that the said appellant also assaulted the deceased by means of a bujali, but the same was not disclosed before PW 6 at the first instance, and only overtact that has been attributed against the appellant Dhruvacharan Sahu was that he instigated the other two appellants at the time of commission of crime. Therefore, the role which has been attributed to the appellant Dhruvacharan Sahu appears to be inconsistent. So, even though the witness, solitary witness, has implicated the three co-accused persons in the assault of the deceased, but the assault in accepted, but that cannot be a ground to disbelieve the evidence of PW 5 in toto. It is the duty of the court that where the grain and chaff are mixed, the court has a duty to separate the grain from the chaff, and if material corroboration is available to the evidence of the witness, the same can be acted upon. Therefore, we find that so far as the appellants Samaru Jal and Padmalochan Dharwa are concerned, they are the role attributed by PW 5 against them right from the beginning before PW 6 and what he has stated before the police, so also in court and before the magistrate in his statement recorded under section 164 CRPC is not only consistent, but it also gets corroboration from the medical evidence as adduced by PW 8. And therefore, we are of the view that the Lennon trial court has rightly found the two appellants, that is Samaru Jal and Padmalochan Dharwa, guilty under section 302 Y34 of the Indian Penal Code. So far as appellant Dhruvacharan Sahu is concerned, since the overtact attributed against him is materially discrepant in nature, it would be very risky to come to a finding that the prosecution has proved its case beyond all reasonable doubt against him, and therefore he is entitled to get benefit of doubt. Accordingly, the impugned judgment and order of conviction against uh, the appellants Samrujal and Padmalochan Dharwa under section 302/34 of the Indian Penal Code and sentenced by pass thereunder stands confirmed. So far as the appellant Dhruvacharan Sahu is concerned, the conviction of the said appellant under section 302/34 of the IPC is hereby set aside and is acquitted of the said charge. Stop. So far as it appears, all the three appellants are on bail. The bail bonds filed by the appellants, the appellant Dhruvacharan Sahu is exonerated from his bail bond. So far as the appellant Samrujal and Padmalochan Dharwa are concerned, they are to surrender forthwith before the London trial court within good time. Forthwith. Failing which, the London trial court shall take immediate steps for their arrest and remanding to jail custody to serve out the sentence. Since the Ms. T. Sinha has been engaged as amicus curiae for the appellant Dhruvacharan Sahu. No,
Dhruvacharan.
You was engaged as amicus curiae for Dhruvacharan Sahu.
That the court has appointed.
He shall be paid a sum of rupees 10,000 from this one to achieve the permanent. So the criminal appeal allow that is Dhruvacharan Sahu criminal appeal. They will be there to dismiss.